Yeah, a couple weeks. Yeah. Okay. That's cool. Thank you.
All right. 14A District Court for County of Washington, State of Michigan is now in session. All those having for the court draw near, the Honorable Judge Simpson preside.
You may be seated. Ms. Lundy.
Good morning, Your Honor. Actually, Lonnie for the people. At this time, people would waive any conflict between this honorable court and the Office of the Public Defender. The people do not believe that any conflict exists. Make the waiver for the avoidance spelled out.
Downtown Lauren Brown. Go ahead.
Good morning, Your Honor. Downtown Lauren Brown, Deputy Chief Public Defender. We likewise do not believe that a conflict exists in this honorable court hearing these matters. If a conflict were to arise, we would waive such conflict so that this court could hear these matters.
Thank you. And the court, for its part, also does not believe that a conflict exists either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the cases of the people versus Dale Miller.
Andrew Childers appearing on behalf of the people, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Miller. Mr. Miller, will you please state your name for the record?
Dale Joseph Miller.
Thank you, sir.
Honor, we're asking for an adjournment. I do have a meeting scheduled with him tomorrow afternoon.
Do we need a couple weeks?
Yes, please.
3 weeks out. 23rd will work for it.
Sure, Your Honor.
All right. Probable cause conference without objection is adjourned January 23rd, 2025, 9 a.m.
Thank you.
Bond will continue. Thank
Mr.
you,
Miller,
sir.
I'll talk with you tomorrow.
Okay, thank you.
Thank you, Your Honor and staff. Have a blessed day.
You do the same. Court does call the case of the people versus Samantha Classic.
Ready, Your Honor.
Good morning, Your Honor. Joseph Halpern on behalf of Ms. Classic, who is not going to be present today.
She's in treatment.
She is, Your Honor, and I'm sorry, I should. We tried to get all docs to both you and to the prosecutor. We do believe she's in a place that's good for her and for her future compliance. I spoke to Sister Counsel yesterday. We've made inroads and family members have communicated with Maple Grove. HIPAA waivers are being executed as we speak. She entered on Monday. She tested on Monday. She will be regularly testing, and one of the HIPAA waivers is going to go to community corrections. So I know Sister Counsel was interested in having regular testing reported for obvious reasons. We have no objection to that, and these waivers should accomplish the same.
And that is correct, Your Honor. I know the court has received the progress report, which did indicate a unable or refused. Then a test that was positive for THC, benzodiazepine, and cocaine, and then a missed sample on January 6th. I have no reason to doubt anything that Mr. Hall is telling me, but this is an extremely serious case. So the people would request a very short adjournment to make sure that we get all of the necessary releases sent over to community corrections so that we can have assurance that she is testing and that everything is going well. And we know where she is. We know that she is where she reports to be and all of those things.
No objection.
When you say a short adjournment, if she entered on Monday and you want testing, then what, 23rd or 30th?
I'll take the 23rd, please.
If
she's not able to attend the 23rd because she's still in treatment, people are going to have an issue pushing it out.
I will not.
Yeah.
Sure. It's my I'm in front of Judge Turfy in person. That's in Dearborn. And I have a Zoom.
They called and said they don't want you.
I don't doubt it, Judge. Somebody's got to take me though, right? So, Your Honor, the 30th would work much better for my calendar. If
January 30th, 2025, 9 a.m. Otherwise, I won't get to everybody else today.
Thank you, Judge.
Thank you.
Appreciate it.
Court does call the case of the people versus David Furman.
Yes, Your Honor, I'm present.
Yes, sir.
Your Honor, good morning. For the record, my name is Mark Burke, P number 54935 for the Attorney General's Office of the People.
All right, thank you. Who's on this? Pardon? You have Jerkus? Furman.
Oh, Furman, Edward Drukas on behalf of, I didn't hear the name. Edward Drukas on behalf of the defendant.
All right. You're requesting an adjournment?
I am. We did have a conversation yesterday. I got to reach out to the AG to try and negotiate the matter.
Any objection from the people?
No objection to adjournment, Judge. I didn't catch the defense attorney's name there.
I'll send you an email.
He said.
I
he'll send
emailed
it.
the other AG thinking he was on it because that was.
Okay, he'll send the email.
Okay, very
You
good.
want the 23rd or 30th?
The 30th, Your Honor.
Probable cause conference, January 30th, 2025, 9 a.m. Bond will continue. Mr. Furman, can you state your name for the record, please, sir?
David Lee Furman.
Thank you. All right, January 30th.
Thank you.
Thank you.
Thank you very much, Your Honor.
Thank you, sir. Court calls case, People versus Russell Exelby.
And good morning again, Your Honor. Joseph Paul appearing for and on behalf of Mr. Exelby, who is approaching. Mr. Exelby, once you're here, if you could state your name for the record, please.
Russell Exelby.
Your Honor, we have submitted a green sheet in this matter as he has been screened by Ted Heaton. He did say that Ted came in and visited him. We don't have an answer yet from Ted sufficient to indicate whether he's eligible or not, which hamstrings the negotiation process. We do believe that if he is eligible, we'll both have an offer and a resolution to this matter. So we're asking for an adjournment so that we can get a response from the sobriety
You
court.
want the 23rd or 30th?
30th would work better for my calendar, Judge.
Probable cause conference without objection, January 30th, 2025, 9 a.m. Bond continue.
Your Honor, regarding Bond,
Bond, yeah.
obviously, Your Honor knows about the tortured history of Bond in this case.
Yes.
Mr. Exelby is prepared to admit that, one, we acknowledge that the tether he was wearing did indicate a tampering event. He doesn't object to the fact that the tether did show the same, and he acknowledges a problem with alcohol. And he'll sit here and tell Your Honor that today. He would like to get out so we can continue getting treatment outside of the jail.
I can shortcut this. I'm not going to consider any release until we get some assessment from the sobriety court.
Thank you, Judge.
And I'll take a look at that after counsel's had a look.
Understood, Your Honor.
All right.
Thank you.
So Bond will continue. Thank you. Court does call the case of the People versus Melvin Langston.
Edward Drukas on behalf of Melvin Langston. He's on his way, and actually, I just received an email indicating that an attorney was going to be substituting.
That what? You received
an email indicating that he may have obtained representation.
Why isn't he here?
I received a phone call as I was walking in this morning from an attorney by the name of Quentin Knox, who says he's been retained. I replied, he sent me an email, which I replied to and CC'd your staff, just to make them aware. But I have no idea if he's planning on attending or not.
I was on the phone about 15 minutes ago. He said he'd be here by 9:30. So I'm assuming he's going to be walking.
He lied.
I'm going to throw myself under the bus for him, Your Honor.
Well, so he's not here. Mr. Dox isn't here. Nobody's here.
I'm here, Your Honor.
Mr. Drukas and I.
Yeah. So you guys aren't doing me any good. I'll pass it briefly.
Okay, thank you.
Court calls the case, People versus, is it Methany Bentley?
Morning, Judge. Torsia, Public Defender. Appearing on behalf of Mr. Bentley. Mr. Bentley, please state your name.
Danny Bentley.
Thank you, Judge. I have had a chance to speak to my client. He's asking for a preliminary examination, please.
Pardon?
He's asking for a preliminary examination, please.
All right. All discovery is complete.
That's my understanding, Judge.
And what date are we on? People have their witnesses available to 21st.
Correct that date, Your Honor. Thank you.
Preliminary examination in person, January 21st, 2024, 25, 9 a.m. before Judge Moore.
Thank you very much.
Thank you, bond will. Court does call the case, People versus Emerson Wilson.
Edward Lucas on behalf of Emerson Wilson.
Sorry, your name?
Emerson Wilson.
All right, what, you're requesting an adjournment?
I'm asking for an adjournment, Your Honor.
And we have a new bond violation report.
Yes, Your Honor, I'm in receipt of that. I don't know if a warrant didn't go out.
Pardon?
A warrant has not gone out on the case.
You want me to issue one?
No, Your Honor.
All right, let's address it then.
Addressing it, he does have an appointment today for a medical marijuana card. The last time I talked to him, it was you can't use until you obtain a potential card and seek that permission from the court. That didn't get done quickly. However, he does have an appointment today. He did provide me proof. We're working on negotiating a potential resolution in this case. He understands and can direct to the court that he will not use until.
Has he been using? I mean, and so before you answer, understand, I don't want to call over and get levels, but I will.
Speaking with him, and he's willing to tell the court today as well, is yes, Your Honor. He's been defying the court order. He thought that him obtaining a card was enough for starting that process. But he understands now and will not be using. And I think if we go out to the 30th, the levels will be going down until he gets permission from the court.
Probable cause conference will be adjourned to January 16th, 2025, 9 a.m. This time defendant's bond is revoked, defendant's remanded. Let's call the case, People versus Sean Caldwell.
Morning, Your Honor. May it please the Honorable Court, David Burke.
Other way.
Sorry, Judge. I'm backwards this morning. Your Honor. Sorry about that. On behalf of Mr. Caldwell, who's joined us this morning.
Your name, sir?
Sean Caldwell.
All right.
Discovery is complete, Your Honor. We're asking for an exam.
People have their witnesses available the 21st. All right. Preliminary examination in person will be set January 21st, 2025, 9 a.m. before Judge Moore. Bond will continue. Thank you. Court does call the case, People versus Maria Valenzuela.
Good morning, Your Honor. Sam Bernstein with and on behalf of Ms. Valenzuela. Can you please state your name?
Maria Ochoa Valenzuela.
Thank you.
Your Honor, we're asking the court to please set this for a preliminary examination. Discovery is complete.
People have their witnesses available the 21st. Preliminary examination in person will be set January 21st, 2025, 9 a.m. before me. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Ronald Calloway.
Your Honor, good morning again. Mark Burke for the Attorney General's Office of the People.
Is he on the screen? He should be. Calloway? Yes. Easter. Where's Mr. Feaster? He's requesting an adjournment. I don't know.
Lloyd Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Calloway.
All right.
That's asking for an adjournment, is that correct?
No. There's a request for an adjournment. Is there any objection from the people to adjourn this matter?
No objection, Judge. The only question I have is, I'm not sure what the bond is on this case, Judge.
All right.
Wait, I do believe it wasn't.
I have his bond at $3,476 cash to be paid to the friend of the court case.
Thank you very much, Your Honor. I appreciate that. No objection to the adjournment.
So, Your Honor, may we address, this is a child support case, is that correct?
It is.
Okay, so, I think the standard.
You need Mr. Feaster.
I'll need.
Okay, can somebody find Mr. Feaster, please?
Yes.
Sorry.
Ready, Judge? Portia Feaster, Assistant Public Defender on behalf of Mr. Calloway. Thank you, Judge. I have met with Mr. Calloway. I've spoken to the people on this case. My understanding, Mr. Calloway does want to waive the circuit court to get this matter resolved as quickly as possible.
Oh, so he wants to waive, so we don't need the adjournment.
No, Your
Callaway, is that a correct statement?
Yes, sir.
You understand the preliminary examination is a procedure where the people would have to show by probable cause that the offense alleged was committed.
You understand that?
Correct.
So, yes.
Yeah.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yeah.
People also waive their right.
We are, Your Honor. Thank you.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Feaster.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
January 21st at 1:30 before Judge Cunkey.
January 21st, 2025, 1:30, Judge Cunkey.
Judge, my client did want me to address one issue regarding bond, if you don't mind.
Go ahead.
Thank you, Judge. I explained to my client the statutory requirements for a child support case and his bond. He wanted to make sure that his bond, to ask the court to set this bond to the lowest possible amount. I told him I thought it might be there already, but he wanted me to confirm that with the court. And if not, he wanted to have it reduced to the lowest possible amount.
His bond is set at $3,476. Which would mean that he would have approximately owed somewhere in the neighborhood of, I don't know what his current obligation is.
I can let you, Your Honor. I can explain that. His current obligation right now is $15,370.58. That's as of January 6th. He has an ongoing support obligation also of $203. The defendant hasn't made a payment since August of 2023. Technically, the bond should be a little bit higher. It should be about $3,800 right now. But
Right.
but I'm not going to make an issue out of that. So
So it is the lowest possible. Thank you, Judge.
Well, it's lower than the
It's
lowest
lower than-
possible.
So it's not.
Do you want me to change it?
Not at all, Judge.
Okay, then we're done with that conversation?
We are, Judge.
We are.
Thank you.
All right, bond will continue. Thank you.
thank you, Your Honor.
Court does call the case of the people versus Malik Ward.
Enter to the defender on behalf of the
Sam Bernstein for Mr. Ward, Your Honor.
Mr. Bird, can you state your name, please? Where is it? Do you have him? Okay, I got him. Mr. Word, can you hear me?
Yeah, I can hear you.
Okay, can you state your name for the record, please?
Malik Ward.
Thank you.
Your Honor, we're asking for a preliminary examination date. I do believe that discovery is complete.
All right, there is an added count 5.
Yes, we can waive formal reading, Your Honor. Mr. Ward stands mute.
All right. Defendant waiving formal reading. Court will enter a not guilty plea as to count 5. And you say all discoveries complete even with reference to the added count.
Yes, Your Honor, it's all.
Would people have their witnesses available on the 21st?
Yes, Your Honor.
Preliminary examination in person will be set January 21st, 2025, 9 a.m. before Judge Moore. Bond will continue.
Thank you.
Court does call the case of the people versus Cody Turnier.
Morgan, please on for the people.
Good morning, Your Honor. Charlotte Steffen on behalf of Mr. Turnier.
Good morning, Your Honor. Marcia Krejci on behalf of Mr. Turnier, I'm here to, my motion withdraw. I mean, not my motion withdraw, but to make sure the withdrawal goes through. I have no knowledge or information regarding Mr. Turnier. I don't.
Mr. Turnier is here. Your motion is granted.
Thank you.
All right. All right. What are we doing on this case?
Your Honor, I am in need of Mr. Turnier's phone number so that I can talk to him about the.
Ms. Krejci, do you have that?
Nobody has my number because I don't have a number. It's been very hard for me to get one.
He doesn't have one. All right.
I'll give you mine. My friend's number, the one that's been helping me.
All right. You'll have to try to put that into the chat so that you don't broadcast it everywhere, and we'll get it over to council.
How do I do that?
Okay. Well, yeah, that's all right.
Sorry,
have it? You have the friend's number?
No, I
what are you trying to hand me then?
Green sheet
Oh.
furniture.
I'm not going to worry about that at this point. I got new counsel. All right. Counsel, you want this adjourned out?
What's your number?
Yes, Your Honor.
The other thing is that I won't address it today, but he may need to appear in person because I've got a violation report from Community Corrections regarding missed samples, 3 consecutive ones.
I actually had a hard time getting to these appointments.
Sir, you might want to talk to your attorney before you start addressing me on that.
Okay.
Positive for THC.
Yes, there was a positive for THC back on December 18th and then 3 successive misses. And prior to that, there was an unable or refuse. So here's what I will do. Sir, you're going to need to arrange to be at the courthouse. We will try to get what information we can to you, counsel, so that you can contact him. But I'll adjourn this out just 1 week to the 16th.
I have a court date on that day.
Pardon?
I have a court date on the 16th at 9:30.
Where?
I'm pretty sure it's going to be at 14-2.
14-2?
Yeah.
Okay,
Yes,
we're
Your
right down
Honor.
the
I
we're
also
right
have
down the
a-
street.
Your Honor, I also have 2 other matters that morning. Would it be possible to adjourn 2 weeks?
Well, I think that I need to address his bond violations. Otherwise, I'll just revoke his bond. We'll come get him, and then we'll set it whenever everybody can be here. Which way do we want to do this?
Well, I understand, Your Honor. We will make arrangements to be there. I'll talk to your court clerk about. coordinating.
Fantastic.
Judge. And
Well,
I
we'll
do
cause-
have Mr. Tournier's phone number from the chat. So Mr. Tournier, I'll be calling you when we hang up here.
Okay.
January 16th, 2025, 9 a.m. Bond
Thank
at
you.
this time. Bond at this time is continued. Thank you.
Thank you.
Court calls the case, People versus Alejandro Montano.
Rachel is appearing on behalf of the people.
That one. Okay, even though you already told him another court date, you being late to that, he should not lock you up.
Good morning, Your Honor. Marcia Krejci on behalf.
Your motion's granted.
Thank you.
Ms. Constantino's on this case. He's at the Bureau of Prisons and they did not sign in because of the holiday.
Federal holiday.
Today?
Yeah.
I'm out. What is, what day?
The state funeral for President Jimmy Carter.
I should not be here.
We were hoping that. I wasn't gonna finish that. That it was gonna be a national holiday.
How many cases does he have?
Too many. 12.
He's got like 12 cases? All right, so I got time for my shot. All right. What I'll do, why don't I, if he's in federal custody, let me adjourn it out to the 30th. Will that work for you, counsel?
Judge, I apologize. I can't do the 30th. I could do any other Thursday, though.
Any other Thursday but the 30th? Okay, what? Oh, so just give me a date. Just give me a date, because Bellinger messed everything up. February 6th.
Don't laugh.
Bravo Cause Conference will be adjourned February 6th, 2025, 9 a.m. Bonds continue.
Thank you.
Give me a call on this. We may be able to resolve.
Will do. Thank you.
Thank you. Court calls the case, People versus Destiny Cheatham.
Good morning, Your Honor. Rita, Assistant Attorney on behalf of people.
Good morning, I'm Rob J. Kill on behalf of Ms. Cheatham.
Your name?
Destiny Cheatham.
Thank you.
Judge, can we set this matter for exam, please?
All discovery is complete.
Yes, Your Honor. And this young woman has done everything you asked her to do. She, at community college, she took her GED testing on Monday. She's working now. So she's on.
So that she, what about the GED testing?
I'm sorry?
You said about the testing. Did she do that?
She did.
Yes,
You want
I
to-
wrote in yesterday. And I did my schedule Monday. And I started working through the states for home health care on the 1st.
Tell me about the testing.
I'll get my results in Monday,
And when did you do it?
yesterday, on the 6th.
At community college.
At community college.
Washington.
Yeah.
So you asked her to do it, she's doing it.
How'd that feel?
Good.
So we won't delay this. Can we get a date, Your Honor?
No problem with that. Will people have their witnesses available the 21st? All right. Preliminary examination will be set in person, January 21st, 2025, 9 a.m. That's before me.
Thank you, Judge. We appreciate your consideration.
All right. Bond with it. Conditions will continue. You're going to pass all of those things, right?
Yes.
I'm going to see that certificate at some point.
Yeah.
Judge, and maybe if she does all that, you'd consider removing the tether?
No.
Okay, thank you.
All right, thank you. Good try, Kilowald. Court calls the case, People versus Desmond Markowski Smith.
And then on behalf of people,
Wow. Hold on. Say that again.
and then on behalf of people.
That sounds so good. All right. Your name, sir?
Desmond Markowski Smith.
I know. He's like Mr. Magoo.
Markowski, Judge, I was just appointed on this case. Although he has a case in circuit court that I was appointed last week to. It's my understanding this young man would you consider a bond motion on this, Your Honor?
If it's a short bond motion, I'll hear it. Otherwise, if it's going to be extensive, you're going to need to put it in writing and then I'll hear it at some other time.
No, it's just very briefly, he's employed. He can be employed, Your Honor. It's my understanding, he'll obey any court order. He'll show up for the next court hearing. And I believe, speaking with him, that it'd be better off that he were out. He and I could more capable represent him.
Response.
Your Honor, it's my understanding probation violation of which a bond is denied. That's all.
Is that correct?
Judge, we were in front of Judge Kunke yesterday. She adjourned it a week so we could make this argument today. She said if we were successful in reducing his bond today, she would strongly consider her bond denial.
But his. All right, go ahead, Kim.
Your Honor, we would still be concerned and object to any modification. He has a previous history of assault with a dangerous weapon, home invasions, misdemeanor. Pushed her onto the bed and hit on her for 6 to 8 seconds. Instead, we think this is the case. He broke switch her 50 daughters and left. And after she left, he took her keys and wallet in her hand. We would have great concern for her safety as well as.
Judge, the only comment I make is
I ain't ready.
this was from 2021. You guys have moved on, right?
Oh,
Okay.
Your Honor,
This case,
this is a PR bond because this case is from 2021, Your Honor.
yeah,
Right, it's a PR bond on this case.
I was told in circuit court they had a cash bond on this. I'm sorry, Your Honor.
I have a, so there's no. All right. Motion to modify the bond is denied. I'll leave his bond where it is. He's being held on the circuit court matter. Thank you.
Circuit court. Thank you.
What day did it? I don't think I did.
You did not.
What do you want me to do with this case? Hold on, sir.
Judge, can we just set it for exam?
Are you ready?
Yeah, Judge, it's a 2021 case. I'm familiar with it. I'd like to go to
Will
exam.
the people have their witnesses available on the 21st?
We'll do our best, Your Honor.
I'm just kidding.
Hey, Your Honor, can I speak?
I'll be real fortunate.
About what?
I ain't talked to I don't even talk to Jasmine no more. I ain't talked to deal with her in years. And this ain't even true, what she's saying.
We'll see if the exam.
Preliminary examination, January 21st, 2025, 9 a.m. That's before Judge Moore.
Good. I'll straighten out with.
Bond will continue.
Thanks, Judge.
Court calls the case People versus Casey O'Neill.
Morning, Your Honor. Richard Cunningham, P29735, Assistant Attorney General on behalf of the people.
All right. Good morning,
And
Mr. Kennedy.
good morning, Your Honor. For the record, Orlando Simone, Student Legal Services, on behalf and with Miss O'Neill, who's appearing by Zoom. Miss O'Neill, would you please unmute and state your name for the court?
Casey Lynn O'Neill.
Right. What are we doing?
Thank you. And Your Honor, at this time, if we could set this matter for preliminary exam, discovery is complete.
Right. Would the people have their witnesses available the 21st?
Yes, Your Honor, we could.
Preliminary examination will be set in person, January 21st, 2025. That's me. That at 9 a.m. That is before me.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank you.
Very well. Have a good day. Thank you, Mr. Cunningham.
Court calls the case of the People versus Kevin Chavos.
We're going to get on to the people.
Ms. Cannon.
Just setting it.
Ready, Judge. Torshio Feaster, Assistant Public Defender, standing in for Ms. Cannon. Please state your name for record, sir.
Kevin Shavul Jr. Thank you.
My understanding is we're setting this for preliminary examination, Your Honor, and all discovery is.
People have their witnesses available the 21st. Preliminary examination in person, January 21st, 2025, 9 a.m. before Judge Moore. Bond will continue.
Thank you very much, Judge.
Thank you. Court calls the cases of the people versus Maurice Anthony.
Appearing on behalf of the people.
Assistant Public Defender Chelsea Ridgels on behalf of Maurice Anthony. Your Honor, it appears
Kind of lonely up there, huh?
is here today. I would ask you not to issue a bench warrant. I believe he has a court date in county this morning. I suspect that's where he may be. I do have paperwork showing that.
Well, do we know that's where he is?
I haven't talked to him this morning, but I did speak to him yesterday about how he does have that court date.
Your Honor, I was speaking with Detective Moser from EMUPD yesterday, and I didn't email the court this information. He was charged with a new offense out of Waterford while this case was pending. And as a warrant out of, I know of some warrant Waterford PD that's picked up on, or would be picked up on as a bench here, as well as I think something else out of Oakland County. One for at least 2 felony warrants. I'd ask that a bench warrant be issued, and I'd ask for maybe $20,000.
Bench warrant will issue for defendant's failure to appear in these matters. Bond is set in the amount of $25,000 cash surety. Those warrants will issue immediately.
Thank you, Your Honor.
Thank you. Let's call the case of the people versus Sean Odom.
Edward Droops on behalf of Sean Odom. In the 5001. Public Defender Jay Bellinger on the case ending in 1311, I believe, Your Honor.
Oh, joy. Me. Your name, sir?
Mr. Odom.
Thank you.
Your Honor, in 5001, we're looking for a preliminary examination. To my knowledge, discovery is complete. Same as 1311, Your Honor.
People have their witnesses available on the 21st.
We'll do our best.
Preliminary examination in person, January 21st, 2025, 9 a.m. before judge, before me on both of these matters. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Emily Bates.
I know what's happening on this case. Call Bates.
Yes.
Portia Feaster, Assistant Public Defender on behalf of Ms. Bates. Ms. Bates, please take the record.
Emily Bates.
All right.
Thank you, Judge. I've had Ms. Bates in the past. I've been in contact with her father, and I've reached out to the people in this case. I was attempting to get some information from our Charlevoix County Probation Department to try to help resolve the matter here. That information did not come. Her agent was out of the office, holidays, and things of that nature. If we could have an adjournment for a couple of weeks, I'm confident I can get that information and give it to the people in hopes of getting a resolution.
Any objection from the people? Okay. January 30th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Your Honor, may I ask you, Your Honor, I'm sorry, is it possible to get a later date, a later time? Later than 9?
I set it at 9. Your case could be put into a later block, but counsel would have to make that request of us and
have your father
accommodate it. We will.
Sorry, Judge. Have your father talk. Have your father remind me, Ms. Bates, and I'll reach out to the court.
Okay, thank you so much.
Thank you.
Thank you, Judge.
Court calls case People versus Christopher Peoples.
Your Honor, good morning again. For the record, Mark Burke for the Attorney General's Office of the People.
Judge Torshio Feaster, Assistant Public Defender on behalf of Mr. Peoples. Mr. Peoples, please state your name for the record.
Christopher Peoples.
Thank you.
Thank you, Judge. I had originally reached out to Mr. Awuda Coker. It's no longer his file, so I did not have conversation with the people on this file. We could adjourn this out for a couple of weeks and I'll talk to Mr. Burke, and hopefully we can find out where we stand.
By who? By who? But Mr. Simon did not file an appearance. All right. Sir, your name?
Harry Brennan, sir.
All right. My understanding is you were represented by Mr. Simon at the arraignment, however.
Yes, I did not attain him as my representation, and I would like to ask the court to a request for a court appointed attorney.
This is a public defender case now.
How you doing? My name is Mark Brown. What's your name?
Harry Brennan.
So that Jim charges are aggravated stop.
All right. Warren Brown, Deputy Chief Public Defender, appearing written on behalf of Mr. Brennan. We respectfully request that this matter be set for a new PCC date. Okay. That way we'll have
Probable cause conference in this matter will, without objection, be adjourned January 23rd, 2025, 9 a.m. Bond continued.
Thank you so much.
Thank you.
What we're gonna do.
Court calls case People versus Benjamin Beck.
Morning, Your Honor. Dan Garrett on behalf of Benjamin Beck. He's stepping forward. Your Honor, we were just retained this week. I informed the client I was asking for German PCC, please, for
2 weeks.
discovery.
Hearing no objection, January 23rd, 2025, 9 a.m. Bond.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Alfred Brown.
People. Stephanie Hanna, we have Alfred Brown.
Brown here.
No, Your Honor, I'm not sure why he's not here because we've spoken. He knows the case is being adjourned. There he is. Okay, I was like, I did speak to him, Your Honor. Mr. Brown, could you please state your name for the record?
Alfred Bishop Brown III.
All right. You're requesting an adjournment?
Yes, Your Honor, for some additional investigation. That is correct. I'm requesting 30-day adjournment because once I'm going to send my investigator out. I believe that after that happens, the prosecutor's probably going to want to send somebody out as well.
Or not?
Or not, yes. Oh.
Any objection to the adjournment?
No, Your Honor.
February 6th, 2025, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Thank you.
You need them.
Court calls the case People versus Robin Finney.
Morning, Your Honor. Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Jay Bellinger.
Under supervision of who?
Jay Bellinger.
Are you allowed to pick another?
Chief Deputy Lauren Brown.
Okay, that works. Okay. So your motion granted. She just threw you under the bus. She said, I got business to do. All right. I have before me a plea form. Could you state your name, please?
Yes, Robin Lee Finney.
Thank you. I have a plea form before me that indicates that the defendant would be pleading guilty to the charge of use of cocaine. The 1-year offense upon a successful plea to that charge, count 1 would be dismissed. There's further agreement. It's okay to seek 7411 on the matter.
That's correct.
Yep, that's correct, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Robin Lee Finney.
All right, ma'am, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance, that being cocaine. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes.
And you also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes,
Still wish to plead guilty?
yes.
And to that charge, how do you plead?
But plead guilty, Your Honor.
All right. Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Excuse me?
You signed an advice of rights form?
Yes, Your Honor.
All right. Any question regarding those rights?
No, Your Honor.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Oh, yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty?
Yes, Your Honor.
May 28, 2024, at the location of 229 West Michigan Avenue, City of Ypsilanti, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes, Your Honor.
Had you used it?
Yes, I have.
Did you know what you were using was cocaine?
I did.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be January 22nd, 2025, 11 a.m. before Judge Barr. Bond in this matter will continue.
Thank you, Your Honor.
Thank you.
And for the record, Your Honor, I was hoping we would have court today.
Pardon?
I was hoping we would have court today and we wouldn't be off for the holiday.
Oh, thank you. That is so nice of you.
Low.
That is so nice. You stay with Lauren Brown and don't even talk to Bellinger. You're doing so well. Not only did she throw him under the bus with the Brown thing, she like backed up and kept running over me. I love it. Court calls the case, People versus Frank Cheney.
We'll talk later.
No, you know what, Bellinger, leave her alone. All right, go ahead.
Brian Bowling on behalf of Mr. Cheney. Can you state your name for the record?
Frank Cheney. Thank you, sir.
Your Honor, there's a waiver form before the court.
Yes, sir. Sir, you're waiving your right to a preliminary examination? You understand a preliminary examination is where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you will not have that hearing. You'll circuit court for further resolution. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, acknowledge receipt of the information, waive its formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
February 27th at 1:30.
February 27th, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you, sir. Court does call the case of the People versus Gerald Childs. Yeah, I'm sorry.
Good morning, Your Honor. Amy Reiser, appearing on behalf of the people.
And good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Childs. And then say your name, please.
Your name, sir?
Gerald Childs.
Thank you.
Your Honor, today is a time and date set for the probable cause conference, and it is my understanding that it's going to be a waiver. I've been in touch with Mr. Bernstein, and we've been talking about a resolution that will include count 1, sexual conduct in the first degree, count 2, the GBH, count 3, the FTD, and count 4, the larceny from a person. We do not have an agreement at this time. So the waiver will be on those 4 counts with an added count 5 of criminal sexual conduct in the first degree and an added count 6 of criminal sexual conduct in the first degree.
So count 5 and 6 of CSC 1.
Correct. And the PAT code for the added counts is 750.520B. It's a multiple variable. It'll read exactly as count 1 that the defendant did engage in sexual penetration with Audrey Sharon under the following circumstances during the commission of the felony of assault by strangulation and or defendant aided and abetted one another and effective sexual penetration through force or coercion and or defendant effective sexual penetration through force or coercion and the victim sustained personal injury. With the same penalty, life offense.
So he's going to be bound over on 6 counts.
Yes, Your Honor.
Is that correct? And, all right, very good.
And if the case does proceed to trial, it would be on all 6 counts. We will not remand for a preliminary exam. But the plea negotiations will involve counts 1 through 4. If we don't reach a plea and go to trial, it will be on 1, 2, 3, 4, 5, and 6.
That's your understanding, Mr. Birch?
Yes, Your Honor. We have the raw workings of a deal. It'll eventually be a plea involving just like 1 count. The 2 additional counts will be dismissed later. If we go to trial, they will be present though. So we understand that.
All right. Sir, you're waiving your right to preliminary examination?
Yes, sir.
You understand that preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
Okay. And you understand you will not have that hearing and that you're proceeding to circuit court for further resolution?
Yes, sir.
All right. People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1, 2, 3, 4, and the added counts 5 and 6.
You're not going.
I'm sorry for the waiver, Your Honor. Could you just indicate what the penalties are on counts 1, 5, and 6 for the defendant?
On counts what? On counts 5 and 6?
1, 5, and 6.
Yeah, I did indicate, I think it was indicated that the 5 and 6 certainly were indicated. You understand that those are life offenses, sir?
Yes.
All right.
Thank you.
We understand and waive any further reading, Your Honor. Mr. Child stands mute, and sure, Ms. Reiser will send me an amended information.
Pending and waive formal reading, standing mute to all 6 counts. Court will enter a not guilty plea. Pretrial will be set for. Said 21st.
Yes.
January 21st, 2025, 1:30, Judge Conkey. Bond as denied will continue.
Thank you, Your Honor.
Court does call the case, People versus Stephen Crawford.
Assistant Public Defender Jay Bellinger on behalf of Mr. Crawford.
Your name, sir?
Stephen Crawford.
Thank you. You're requesting a 4-week adjournment regarding treatment.
We are, Your Honor. We are trying to work out a resolution on this. It's going to require some time in order to look at some stuff.
Probable cause conference, February 6th.
Thank you. We also may be sending a stipulated, if I can confirm with the court, if there's a no contact order on this matter, we'll send a stipulated order if we agree on that to the court afterwards. I just want to confirm that there is one.
Regarding a Samantha?
Yes.
All right, there is.
All right, thank you.
So probable cause conference, February 6th, 2025, 9 a.m. without objection. Bond will continue. Thank you.
Thank you. All right, do your homework.
Court does call the case, People versus Nikita Franklin.
Assistant Public Defender Jay Bellinger on behalf of Nikita Franklin, who approaches. Mr. Franklin, can you state your name for the record?
Thank you. Thank you, sir.
Thank you, Your Honor. Your Honor, we are asking to set this matter for preliminary examination. We are also asking to make a quick bond argument.
All discovery is complete.
As far as we know it to be.
People have their witnesses available the 21st. Preliminary examination in person, January 21st, 2025, 9 a.m. before Judge Moore.
Okay.
As to bond.
As to bond, Your Honor, I have spoken with my client. He advises that he can live at a location that the complaining witness does not live at. He's willing to do home confinement, GPS tether. He works for AATA in maintenance. He's been working there for a year now. He's not wanting to lose that source of income. He just had a child. He also has a daughter who just unfortunately broke both of her legs in a playground incident, who's got some pretty bad medical needs right now that he'd like to get out and be able to take care of. So I'm asking for his release on maximally home confinement. I'm just asking that he be able to have an opportunity to be out. He's, like I said, he's willing to do GPS, tether, and any other conditions as set by the court.
Response.
Your Honor, in this case, people originally requested a $200,000 bond, and we would have great concerns on who would object to any bond modification. In this case, on probation currently in the 22nd Circuit Court until March 28, 2025 for an RNO, ammo possession by a felon, and weapon possession by a felon. He also has previous home invasions, breaking and entering, OWI, and in this case specifically, the victim got into an argument, he got upset. He then strangled her with both hands, tackled her to the ground, and their children were present for the incident. And then after he left from the first incident, he came back, assaulted her again by pushing her along the pit, right out of her hair. At the time of this incident, she was also pregnant. He was upset about the pregnancy, so we would have objections to any modification.
And you're indicating he was on bond at the time of this incident?
I believe he was on probation.
On probation, I'm sorry.
He's on probation current.
And was he on at the time that this offense occurred?
Yes, Your Honor.
All right. Anything else?
We would just provide to the court that those are just allegations at this time, Your Honor.
Motion for bond reduction is denied. Bond will continue. Thank you. You got something? Thank you. Court calls the case People versus Antonio Kraut.
And good morning, Your Honor. Assistant Public Defender Shanazi Carey. I can really, on behalf of Mr. Antonio Kraut, who's approaching. Mr. Kraut, state your name for the record,
Antonio
please.
Kraut. You need to take your hands out of your pockets.
Sorry, sir.
All right. Go ahead. What
Judge would like to set this matter for preliminary examination.
All discovery is complete.
To my knowledge, Judge.
People, other witnesses available the 21st.
We'll do our best, Your Honor.
Preliminary examination in person, January 21st, 2025, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Thank you. Bond will continue. Oh, welcome back. No, I'm just, whatever. No. Him and Bellinger are going to have a day. Court calls the case People versus Brady Peterson.
Morning, Your Honor. James Fifelski, standing in for counsel of record on behalf of Mr. Peterson. State your name, please, sir.
Brady Peterson. You have any objection to Mr. Fifelski standing in?
No.
All right. Thank you.
Your Honor, we would like to keep this on for preliminary exam at the next available
Is all
date.
discovery complete?
I believe it is, Your Honor. Also like to argue bond if I could.
Would the people have their witnesses available the 21st? Preliminary examination in person will be set January 21st, 2025, 9 a.m. before me. As to bond.
Your Honor, as to bond, it's my understanding bond is currently set at $150,000 cash, maybe surety. It seems pretty high given the fact that these are 10-year felonies. My understanding is that Mr. Peterson does not have any adult felony convictions. He has been gainfully employed at Blue Star Demolition in Macomb County, where essentially he has been raised in Macomb County. So minimal contacts in Washtenaw County. Understand he has not had any contact with the complaining witness since October 15th and has had no reason to. They broke up. They haven't had any communications. So he really has no reason to be in this county, but for the court proceedings, and otherwise has a resident with his aunt, I believe.
Yes.
In Clinton Township that he'd be able to either be tethered to or home confinement with work. Some way, Your Honor, that can, I believe, assure the court that though he won't have any contact with the complaining witness and he will continue to appear for court proceedings. And lastly, he also has two children. One is a stepson that he has joint custody over and cares for him back at home in Clinton Township. He also has a 6-year-old son who passed away last year unexpectedly from a rare heart disease. So I think he is a good-hearted family man that will take these court proceedings seriously. Just ask for a significant bond reduction so that he can post something reasonable.
Response.
So we requested 250,000 cash or surety. I understand that it was set at 150,000 cash or surety in this matter, but that's still lower than what we asked for. There were 2 counts of strangulation because, to our knowledge, there were 2 counts of strangulation that occurred over a time span. The defendant also has 3 holds, one out of Buena Vista Township for 15,000, a hold out of Davidson Township for $100, and a hold out of Clinton Township for 10,000, 10%. He has a lengthy criminal history dating back to 2010 with a juvenile adjudication for armed robbery. He also has 2 convictions for DV second and R&O, and interfering with a crime report, maluse, obstruction by disguise, as well as numerous dismissed DVs. In this particular case, the police were contacted for a welfare check by the victim's mom, because despite the fact that the victim and the defendant were broken up, the defendant had been sending out sexually explicit material of the victim to other parties, including the victim's mother. When law enforcement contacted the victim, it was only then that she disclosed these acts of violence that occurred over the span of 2 months. These particular incidents are 10-year felonies, but they are rather severe strangulations. The victim in one incident described the strangulation by being lifted off of the ground by the neck with both hands. She ended up on her back on the floor where she continued to be strangled to the point of almost losing consciousness, describing it as if she was seeing stars. She had photos documenting this with large bruising on both sides of her neck, consistent with fingers gripping. The fact that there was continued conduct after the breakup makes me concerned that the fact that they're separated is not the conclusion of this and is not the end of the threat that to the victim. I don't think that any reduction below 150,000 at this time is appropriate.
Your Honor, I would just respond by stating something like a tether or even home confinement in Macomb County, which is at least an hour away from Washtenaw County, would be significant to protect not only the complaining witness, but the community. And I don't think otherwise, with strong community ties in Macomb County, my client is a flight risk to fail to his obligations to this court. The details of the case can be dealt with at preliminary exam, and I can't speak to that other than the fact that I think 150,000 is excessive given the fact that these are not capital or more serious felony offenses.
Motion for bond reduction is denied. For police and bond is set as is appropriate. Thank you.
Thank you, Your Honor. Have a good day.
Court does call the case People versus Durrell Davis.
Action on people.
Assistant Public Defender Chelsea Vergils. I believe Mr. Davis.
You're just having a rough day, aren't you? I mean, you come up here twice, you don't have a client.
No,
I'm feeling bad for you.
It's all great. Mr. Davis is.
Oh, your client's here. See, I knew it. I had faith.
Thank you.
I was just stalling for time for him to get up here. All right, go ahead, Ken.
Your Honor, we have provided a plea form.
Yes.
Mr. Davis would like to take the offer to plead guilty to controlled substance use.
All right.
Your Honor, to be clear, that is use of methamphetamine, which does have a different PAC code than use of controlled substance, which we do use in many other pleas. That is MCL 333740428. That's use of methamphetamine, which is a 1-year misdemeanor and or $2,000 fine. Upon successful plea to that, count 1, possession of methamphetamine, 10-year felony, dismissed, no delay, no deferred, no 7
That's the court's full understanding of the agreement. Is that correct?
Yes, Your Honor.
Let's have him sworn.
Right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. State your name. Drew Davis.
Sir, it is this court's understanding that you're going to plead guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Say it again.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? No. Please look at paragraph 5. You see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense? On the date of August 6, 2022, at the location of Parkwood Avenue in Ypsilanti Township, Washington County, State of Michigan, did you have methamphetamine in your possession?
Yes.
Did you know you had it?
No idea. Yes. No. No.
Okay, you had methamphetamine in your possession.
Yes. Yes.
Had you used it?
Yes.
Did you know what you were using was a methamphetamine?
Yes.
You did?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
I'm satisfied.
Defense is satisfied.
Court will accept the defendant's plea to guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
February 13th at 10 a.m. with Judge Washington.
February 13, 2025, 10 a.m. before Judge Washington. Bond will continue. Thank you. Court does call the case of the people versus Martin Graham.
Brian Bowling on behalf of Mr. Graham. Just state your name for the record. Your Honor, we're requesting this matter be set for an exam. I believe the discovery to be complete.
People have their witnesses available the 21st. Preliminary examination in person, January 21st, 2025, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Bond continue. Thank you. Court calls case of the people versus Kyle Rainey.
Assistant Public Defender, really, Your Honor, on behalf of Mr. Cal Rainey, who is approaching.
That's what I was looking for. Why? Go ahead.
Your Honor, today is the date and time set for probable cause conference in this matter. I know the court would want to first address Mr. Rainey's bond violation.
Yes.
I know. So, Your Honor, Mr. Rainey was released from custody. I don't have the date in front of me. However, upon his release, Your Honor, he
left the state.
He did. He left the state of Michigan and he went to Indiana. When he was released, Your Honor, he indicated to me that he was displaced and he did not have a place to stay. He did have a tether on. He indicates that he contacted the tether agency. He contacted the emergency number to see if he would have permission to go and stay with his grandmother in Indiana. He states that he did not receive any information back. I did not receive any contact from Mr. Rainey, but it was during the holiday period, Judge. He has been in contact with us.
Was there a call to your office at all?
There was a call to my office. He called us. It wasn't prior to him going. I will say that. However, he did call and say, I'm in Indiana. I didn't have anywhere to go. I've been trying to reach out to my agent, but to no avail. He's got that other case in Hillsdale County. He's been reporting. He's currently on probation there. He has been testing. To our community.
No, not serious.
Okay. He is, Your Honor, he has not been using any substances. He has been clean. The only reason he went there was because he did not have a place to stay. He stays with his grandmother in Indiana. I have explained to him that prior to leaving the state, he has to receive permission from the court to enable him to go wherever it is that he's going to go.
ended up getting in Litchfield one day.
Okay. He indicated that he was
You
only
need to take your hands out of your pockets.
He indicates that he was only in Indiana for 1 day. He has been back now.
1 day too long.
1 day too long, Your Honor. He has been able to secure housing here in Michigan, in Litchfield.
Litchfield, Michigan, where I'm from.
In Litchfield, Michigan, where he's from. Your Honor, he has been very, very active in this case right from the beginning. We know that it took us a minute to get him out of custody. And obviously, he does not take that for granted, Your Honor. His violation of this bond was not, although it was very much so a violation, Your Honor, he doesn't want the court to perceive it to have been a disrespect to the court. He takes this case extremely seriously. We've been working with the people to see if there's a resolution. Right now, we do not have a resolution, mainly because this outstanding issue needs to be resolved first. We're asking that the court allow him to stay out. The tether is doing exactly what it's supposed to do. Obviously, it didn't stop him from going, but he knows now that he is.
No, he knew then.
Your Honor, I did know then. I had nowhere to go. I was left out here. When I got arrested, I was in summer clothes. They were able to give me a hoodie. It was the middle of winter. I contacted everybody that I could contact, and I apologize.
No, you didn't contact everybody you could have contacted. And you get a response. Any response from the people?
The concerns of the people are just, I think the court recalls when we were here last time, the defendant was able to secure a PR bond after having been spent 7 months in Hillsdale, coming back here. So when he was gone, he wasn't gone somewhere else, he was in Hillsdale. But the concern is still that there was a failure to appear, I believe, at some point during the case. That may not be accurate, and I apologize if it's not, but the issue is, he was on bond for a CCW at the time of this possession case. He leaves the state. I don't know if he's been testing. I don't have that information. I don't have anything to say he's not. I just don't have any information he has been testing. And there are, clearly had the ability to get all the way to Indiana. So I'm not sure why there wasn't some sort of communication with his attorney or something else to make sure that he was gonna follow the bond conditions that were set by this court.
And Your Honor, if I may, just very briefly, he indicates to me that he has been testing. He's been testing in Hillsdale. He's on probation out there. His attorney in Hillsdale, he states that she forwarded the testing results to community correction. I don't have a copy of that. I can absolutely reach out to them and see if I can get that. But Judge, we're really asking that the court give him another opportunity. He's been in custody for 7 months, in and out of Hillsdale. I mean, between here and Hillsdale.
And he just needs to follow the court's orders. It's really simple. Anything else?
Like I said, I got a place here.
Nothing else, Your Honor. He just wants the court to know that he does have housing in Michigan now.
Probable cause conference will be adjourned to January 16, 2025, 9 a.m. This time, the defendants remanded on the warrant. Community correction for violation of his bond.
Thank you, Your Honor.
Court calls the case, People versus Desiree Radnovich.
Yep, right here.
Okay, hello.
Rob Chico on behalf of Mr. Bogdanovich. Judge, we've adjourned this PCC. Due to the holidays, it was tough to get an appointment with her. I have an in-person appointment with her tomorrow at the Huron Valley Women's Prison at 10 a.m. Could we just adjourn this PC maybe 1 week?
Are we kidding again?
I have to go 2 weeks because I can't.
That's fine. Ms. Bogdanovich, no matter how hard I tried, I just couldn't get a visit with you because of the holidays. That's what they told me.
I've been sitting in front of the phone for 4 hours waiting for you to call.
on 2 occasions. I don't feel like you're trying to contact me at all.
I can't directly contact you. I have to go through the system and they wouldn't allow it.
They had me sitting in front of a phone for you.
Hey, hold on, folks.
I'll be there
Okay.
tomorrow, 10
Hold
a.m.
on. Maybe he's supposed to be down there tomorrow. I can't rectify what may have occurred in the past, and we'll get you heard as soon as we can, okay?
Okay.
All right, so probable cause conference, I'll adjourn it. I have to go 2 weeks out. I would put it 1 week out, but we have to do the whole writ procedure to get you before me. So I'll go to the 23rd, the next date I can possibly do it.
That's fine, Judge.
2025 at 9. Bond in this case will continue. Okay, thank you, ma'am.
Thank you.
Court call. Court calls the case of people versus Zachary Radcliffe.
Good afternoon, Your Honor. Amy Reiser, appearing on behalf of the people. Will you call this one?
Your Honor, James Thomas, or Ms. Radcliffe.
Okay, what are we doing?
Your Honor, today is the time and date set for the probable cause conference, and all of the discovery has been provided. There are still some electronic devices that are outstanding, but I don't know when those will be done. So I think we could get an exam date, and I would be requesting a special date. I think it will take like a full day.
All right.
Well, Judge, just let the court know, she did provide 8 videos on Monday that are, I don't even know how many hours of videos that I have not had an opportunity to even look at yet. These were things that were requested over a month ago and just got them Monday this week, which puts me in a predicament because obviously my guy's locked up and I would want to have my client be able to watch these videos, which calls into question his bond and the amount of his bond, because I would like to seek or at least ask for an oral motion to set a bond or reduce his bond at this time if the court would entertain that.
Well, I'll always hear bond, but I guess I don't understand your rationale for bond is because you can't view the.
Well, there's a couple of reasons for it. One, obviously the limited contact that I'm able to have with my client as far as all the hours of evidence that they just provided to me this week, for one. 2, when he initially was in his preliminary presentation, there was not an assessment that was done whatsoever for the bond. He had an attorney there, but according to my client, the attorney really didn't say anything on his behalf, and a $3 million bond was put into place. And at that point, none of
All right, counsel, if you want to argue that he didn't have an adequate opportunity to argue bond, I think each time you've been here, that issue has been brought up.
Never.
But if you, okay, then fine. You want to file a written motion? File a written motion. We'll give you a special time. I'll give you all the time in the world. I'll hear your bond motion. How long will it take you to do the motion?
I could have it this week, Your Honor.
People need about 7 days to respond, if that.
Yes, Your Honor.
But the only thing I'm out of the country from the 21st to the 28th of January.
I got a holiday before that, so I can't. If you're not here till the 28th, I can't hear till the end of the month.
What day do you hear them on, Your Honor?
I hear them on Thursdays in the afternoon.
What day does that fall on?
Pardon?
What day does it fall on, Your Honor?
What do you mean?
The one that you were thinking about putting it on.
Well, if you're out between the 21st and 28th, the only Thursday I then have is the 30th.
I mean, I can make the 30th work if that's the earliest we can get.
I'll adjourn the probable cause conference and set the bond motion to January 30th, 2025, 3 p.m. That is before me at that point for the bond motion.
Judge, would you like a courtesy copy to your email or to?
I think the court rules require that you need to send me a copy so you can deliver it to the court, or you can send it to the email of my clerk or
Yes, sir.
my staff.
I suggest we set an exam date.
It's not going to happen until discovery is all complete. He's saying discovery's not, I'm not going to do it. What I'm going to do is he wants to hear the bond motion. I'll hear the bond motion. It says that you just got discovery to him. I don't set him that way. I'm not going to set it. I'm going to hear the bond mark. 30th.
And so I just want to make sure we're all on the same page. The discovery that he doesn't have may never come because it's passcode protected.
And then I understand that because that was brought up before me before. If he wants to give him the passcodes, then I think that discovery can get there, but I don't think that's going to happen. So I'll hear the bond motion on the 30th and then we'll see where we go from there.
Your Honor, just so I know, I know that she's saying that there's other stuff that's out there possibly with subpoenas and stuff that she has out there. I'm not sure where.
What subpoenas?
No, I didn't say that.
Well, is there other notices out there for anything else that you're doing with other than his?
I hear that there is electronic devices that are password protected that is going to take some time to get into, that he may have the passwords to, but I don't think he's going to give them. So we're just going to have to wait on that. That's what I'm hearing.
Okay.
Anything else?
No, thank you.
No, sir.
Wonderful. We'll see you on the 30th. First case, People versus Tariq Day. Hey, guys, hold it, folks. Hold on a moment. Who's who is that everybody? I just want to make sure. So anybody with defense counsel that was here, they've left already or they're on their way out? Okay, let them go first. I know I try to alternate, but I probably got it all wrong, folks. I'm sorry, but I just don't want anything. Let them go. And then, folks, if you would be patient, once they've cleared, then those folks can leave. Thank you. Court does call the case of People versus Tariq Day.
Brian Bowling on behalf of Mr. Day. Mr. Day, are you present? Your Honor, I've called his name numerous times this morning. I was unable to reach him in advance of today.
Bench warrant will issue for defendant's failure to appear, bond set in the amount of 10,000, cash surety. That warrant will issue immediately. Thank you. Court calls case People versus Marcel Steger.
Andrew Children's attorney on behalf of the people.
Good morning again, Your Honor. May it please the honorable court. David Burgess on behalf of Marcel Steger. Your Honor, discovery is complete in this matter. We are requesting an exam date. I believe. Go ahead. Sorry.
Steger's co-defendant to Mr. Word, Lee Word, who we called earlier, and we set that for the 21st, I believe, Your Honor.
That's correct, Your Honor.
It was with Judge Moore.
Okay.
Yeah, that's correct, Your Honor. I was just gonna make sure the date was the same.
All right. Preliminary examination in person, January 21st, 2025, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Thank you.
See you.
Bond continued. Can you, could one of you just, I see the trooper back there, but one of you check just to make sure they cleared, and then I'll release them. Pardon? It's empty, they're cleared. Okay, you folks can go ahead. Thank you for your patience. Court does call the case, People of the State of Michigan versus Kellen Dixon.
Andrew Childers, claim on behalf of the people.
Kellen Dixon.
He didn't hear you. He did not, Judge. Apologies. Ready, Judge Torshio Feaster, Assistant Public Defender on behalf of Mr. Dixon. Mr. Dixon, please state your name for the record.
Kellen Dixon. Thank you.
Thank you, Judge. I spoke to Mr. Dixon. I understand from the notes he had been working to try to resolve the matter. He has asked that I set this matter for preliminary examination to try to get it moving forward, Your Honor.
All discoveries complete.
That's my understanding, Your Honor.
People have their witnesses available the 21st.
We go 1 week past that.
Any objection?
No, Your Honor.
Preliminary examination will be set January 28th, 2025, 9 a.m. in person before Judge Washington.
Judge, I'm sorry. My client just informed me he has a court date in Flint on that day.
February 4th work for everybody?
Yes, Judge.
That's fine.
February 4th, 2025, 9 a.m. before Judge Fresh Hour.
Thank you, Judge. February 4th.
Bond will continue.
Let's call the office. Thank you, Judge.
Thank you. Court calls the case. People versus Ontario Woods.
Childers, agreeing on behalf of the people.
Morning, Mayor. Edward Lucas on behalf of Ontario Woods.
Ontario Woods.
Your Honor, we'd like to set this for a preliminary examination.
All right, there is an added count for us. Let's do the arraignment on that.
Stand mute, waive reading.
All right.
Mr. Woods is the third co-defendant, Mr. Steger and Mr. Word.
Got it. All right, so he's being arraigned on count 4, stood mute to those charges. All right, null discovery to your knowledge.
To my knowledge, is complete.
And so we would be setting this one on the 21st. So preliminary examination in person, January 21st, 2025, 9 a.m. That's before Moore, correct?
Yes.
Before Judge Moore. Bond will continue. Thank you. Court calls case People versus Jaden Dodge.
After the people.
Stephanie Cannon, we have Dodge who's appearing by Zoom. Mr. Dodge, could you please state your name for the record?
Hi, my name is Jaden Dodge.
Thank you. What are we doing?
Your Honor, my client would like to exercise his right for a preliminary exam. I do believe all discovery has been provided.
People have their witnesses available the 21st.
Can we please go 1 week further on that now?
Any objection to that?
No objection, Your Honor.
Preliminary examination, January 21st, 2028, 2025, 9 a.m. in person before Judge Washington.
That was January 28th, 2025, at Judge Washington.
Yes, ma'am.
Thank you.
Bond will continue.
Thank you, Your Honor.
Court calls case People versus Michael Harris.
Good morning. We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, Quinn Withen, on behalf of Mr. Michael Harris. Mr. Harris, please state your name for the record.
Michael Harris.
All right, go ahead. Time set for a probable cause conference and a bond violation hearing. With respect to the probable cause conference, we are respectfully requesting that this matter be set for preliminary examination. First available date. We do believe that we have all discussed.
What?
And we have all of the discovery in this.
All right. And as to the bond violation?
Your Honor, my client is pleading, like to be heard on that because we'd like to address the bond. So I think in order to address the bond, you want to address the bond violation.
Say again, I'm sorry.
So he'd like to address this bond. And then I think in order to address the bond, you have to address the bond violation. So in brief, the bond violation here is that he had contact with the complaining witness in this matter. He was found in a vehicle. He's driving a vehicle. She was also in. I've had a chance to speak with my client. He told me that the reason that he was in that vehicle is that he was taking the complaining witness to the hospital. Basically, they really don't have anybody but each other around here. He knew there was not supposed to be any contact. She came and picked him up. She complained that she had serious back issues and she was going to the hospital. She needed him.
Is there any medical that you have to go along with that? Or
he would not have it. He was stopped on the way to the hospital. The police arrested him. She did inform him that she informed the police, at least from what I know, that she had the back issues, that she needed to go to the hospital and he was taking her.
She was taken there?
He was taking her there. I don't know if she went. He was gone. He wasn't able to get follow up, and HIPAA won't allow us to do any follow up.
All right. Well, here's what I'm going to do. Would the people have their witnesses available the 21st? I'll set his preliminary examination January 21st, 2025, 9 a.m. before me. I'll let you go ahead and argue bond. I'm unlikely to do anything because it's a violation and I would need some.
So yes, I understand you. We absolutely understand. I talked to him about it. He would like to have the bond reinstated, even if the court wanted to up the level to a tether or something. But once you hear the bond, the issue on the bond violation, you understand why he did it. And it was in the
No, I get why you're saying that. And I have the report, so I see some of that. But what I don't have is the other piece to it.
Right. I know. I understand what you're saying.
Okay. So here's what I do. I'll say no at this time. Do the people know whether or not you have any information regarding the alleged victim in this case actually making it to the hospital and some documentation there?
She is. She's back there in the back.
Okay. Do you know whether or not the alleged victim is saying that also, or no? Do we know? Oh, she is. Oh, okay. So, ma'am, I'll just ask you this. I don't need to know specific details of anything. Did you make it to the hospital? Yes? Okay. I'm going to need some medical documentation. You can black out whatever you need to, but the fact that she went there, I need documentation of that. And then I certainly, Mr. Brown, will reconsider his bond at the time that I received that. So she needs to get that from the hospital that she was there. I mean, even discharge paperwork will do for that purpose, but it's got to go to the prosecutor, to defense counsel, and then I can make my decision on things. Okay. So at this time, I'll deny the bond. I'll have it set. They can get that to me at any point. They can get it to me. Or what's he trying to read now? All right. So at this point, his bond will continue. All right. Get that. Okay.
Thank you.
Get that. Okay.
All right.
Thank you, Your Honor.
Thank you. Court calls case of the People versus London Daughtry. Or, I guess it is Daughtry. Or Daughtry.
Good judge. Portia, please. Mr. Doctor. Mr. Doctor, sorry. Doctor, state your name for the record.
London Daughtry.
The Daughtry, apologies, Judge. I believe you should have a green sheet in the file.
I do.
Okay. This is the first pretrial on both of the PCCs on both of these files, Your Honor. Going to talk to the people about trying to get a global resolution on them, Your Honor.
January 30th, 2025, 9 a.m. Bond continues.
Thank you, Judge. January 30th. That's your next date, except for 9 a.m. I'll get that out.
Oh, really?
Thank you, Judge. I'll write some down.
Who has to be in front of what?
Mr. Docket, who is the one who's Jocks is supposed to be coming in.
Is Langston here?
Yes, he is.
The defendants here?
Yes.
Court does recall the case of the People versus Melvin Langston.
Andrew Childers appearing on behalf of the people.
Good morning, Your Honor. Edward Dukas on behalf of Melvin Langston, who is approaching.
Your name? All right.
Your Honor, I was asking for an adjournment for further negotiations. It does sound like as of this morning, he has obtained counsel. I haven't signed a substitution or had that attorney reach out to me yet. I would be ready at the next hearing if that attorney.
All right. So you need to be here on time. You understand that?
Yes, sir. So I'd ask for just a 1-week adjournment.
Just one?
Well,
I'm going to go 2.
2 would work.
January 23rd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Thank you. Court calls case People versus Stephen Hensel.
Ashley Lonnie for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Hensel, who approaches, Your Honor. Mr. Hensel, can you put the record?
Stephen James Hensel.
Thank you.
Thank you. Your Honor, I have checked with my office on a mitigation that we'd started several weeks ago. I think the holidays kind of held that up. I have no choice but to ask for an adjournment for that reason so that we can get that in over to the prosecution for a consideration on an offer. I would also like to ask to address bond briefly.
Okay, how much time are you going to need to try to complete the mitigation?
The mitigation, I believe, is already completed. It's just going through the editing process for the final draft. So I'm just going to ask for 2 weeks.
All right, but is that going to be enough time to get that there, have them review it, and then have meaningful discussion? That's all
I think so, Your Honor. I try to work rather quickly in cases in custodies.
Probable cause conference will be adjourned then to 23rd, 2025, 9 a.m. All right.
As to bond, Your Honor.
Briefly.
Thank you. I have spoken with Emily Kenders from the CMH. She has informed me that Mr. Hensel is agreeable to start services with community and mental health on the outside upon his release. He's really interested in therapy. He is engaged with CMH inside the jail. However, it's my understanding that he's not interested in starting on medications within the jail because he's had an experience where he's been over-medicated in the past. So we would be asking for his release on PR bond today so that he can start those services with community and mental health. As I stated, he is already with services in CMH as it stands.
Any response from the people?
I have the same concerns I've been expressing all along. I can understand that a person may have resistance to medication, had a previous bad experience with medication. However, one of the biggest things that we see is that folks who require mental health or drug treatment don't dictate the terms of their mental health or drug treatment. They are, in a lot of ways, are asked to trust experts with what needs to happen with them. So the concern of the people is that
the behaviors will continue on the outside like they did before, and that there will not be adequate protections for the safety of the community if the defendant is not receiving all the treatment that his care providers deem necessary.
All right, so just based upon what is said, and I still have the similar issues I think that I've expressed before. So
If I may,
the problem is going to be that what you said is there, it's almost an incongruent statement saying, I understand what may be the fear over medication, but then not having a willingness to start treatment while in custody. Yeah.
presently, I'm not symptomatic. I've been stable for months, and in October, when reviewed by the Center for Forensic Psychology, if you look at the report, there was no indication of any problematic symptoms. I was actually deemed pretty intelligent and understanding of what was going on. And I'm productive in here. I've been reading textbooks. I've been doing pretty high quality art, if I may. And I would say that the concerns of the people are noted, but I don't think it's necessary. I've never had homophobic slurs thrown at me. I've never had somebody threaten to cut my throat, and that's happened to me in here. And I would say I'd be safer on the outside.
So for those reasons, Your Honor, again, we would refresh our request and asking for bond for him.
I'm going to deny the request at this time. I mean, I'm going to have something in place. I think I've indicated that, Mr. Bellinger, and maybe once the mitigation gets through. I don't have a problem with release, but it's going to be under some structure and so that maybe you can explain this to your client and you can hear me clearly. It's going to be on the terms dictated by those professionals, not his terms, and then also the court's terms. That's how a release will happen in this.
Understood, Your Honor.
So at this time, bond is denied.
Thank you.
Bond. Both for bond. Thanks. Court calls case People versus Gregory Douglas. This is my last.
Yes. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Douglas, who should be appearing via Zoom. Got it.
You think it may be? Okay. Gregory Douglas? Is that you?
Speaking, sir.
All
Speaking.
right.
You got, am I here?
We can hear you now,
We
sir.
can hear you.
Thank you, Your
All
Honor.
right. I have a plea form that indicates he's going to plead guilty to the charge of larceny 200 to 1,000 to 1 year offense. Upon a successful plea to that charge, count one would be dismissed. I noticed one problem here. The larceny 200 to 1,000 should be 1 year or $2,000 fine plus court costs like that.
I'm so sorry. Remind me, can I change? I apologize for that mistake on the plea form.
All right. And then there is an agreement of no delayed or deferred. All right, although I can't find the sentencing judge, but all right. That's the correct understanding.
That is correct. I will inform the court because Mr. Douglas is on Zoom. I did provide him with an advice of rights form via email. We did review that and discuss his rights regarding this. I also discussed with him a sentencing judge waiver, and he would waive his right to a sentencing judge.
All right.
And it is a no contest plea.
It's a no contest.
Yes.
There it is. All right. Sir, please raise your right hand. Do you solemnly affirm testimony it will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I do swear.
All right. State your name again for the record.
Gregory Douglas.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of larceny 200 to 1,000. That is a misdemeanor, punishable by up to 1 year incarceration and a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
I do understand.
All right. Do you understand what a no contest plea is?
I do understand, Your Honor.
All right. 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
I do understand that.
All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I do understand that, Your Honor.
All right. You understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge Valvo in the 15th District Court.
I understand, Your Honor.
All right. Basis for the no contest plea?
Potential civil liability, Your Honor.
All right. So understanding all of that, to the charge of larceny 200 to 1,000, how do you plead?
No contest, Your Honor.
All right. You understand that by pleading no contest, you'll not have a trial of any kind.
I understand, Your Honor.
All right. Because of that, and you reviewed an advice of rights form, is that correct?
I did, Your Honor, this morning.
All right. Did you have any questions regarding any of those rights?
I do not, Your Honor. I understand fully.
All right. And you understand that you'll be giving up specifically those rights. Well, you'll be giving up all of the rights on that form, but specifically the rights contained in paragraph 5 on that form.
Correct, Your Honor.
All right. You understand you're giving up your right to appeal of right.
I understand that. I'm giving up my right to appeal. I understand.
Well, appeal of right. You understand that?
I understand, Your Honor, fully.
All right. Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, no one has threatened me.
You're doing this voluntarily?
I am doing it voluntarily, yes, Your Honor.
And of your own free will?
Yes, Your Honor.
Court has been provided and is reviewing the Ann Arbor Police Department report for their case number 23-40790. Any objection to the court reviewing that report?
No, Your Honor.
No, Your Honor.
Based upon a review of the report, the court does find a sufficient factual basis in which the court could determine the defendant's guilt of this offense. You're taking it to the higher charge also because of the value issue. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
February 6th at 1:30 before Judge Valvo.
February 6, 2025. I'm sorry, 1:30. 1:30 before Judge Valvo. Bond will continue.
Thank you very much, Your Honor.
Thank you.
If you're interested,
Who gave him the wrong date?
Lauren Brown is the messenger.
Lauren Brown did?
Yeah.
No, he's the messenger.
Well,
I bet you it was Bellinger.
It was not.
It was Bellinger. It was Bellinger. Everybody quit trying to protect Bellinger.
it was Ballinger.
It was Bellinger. Until he fesses up on that. The court calls the case People versus Piyush Singh.
And good morning, Your Honor. Sarah Kraus. I'm standing in for the attorney of record, Gabi Silver, for Piyush Singh, who is present in your courtroom. Mr. Singh, can you state your name for the court, please?
Piyush Singh.
All right. And you have no objection. Are you with the same firm, counsel, or no?
I am.
Okay, very good. Then I don't have to ask that. Very good. Oh, sad. Hold on. Okay. I just took his play. Kick him out. Okay, good. All right. What are we doing on this?
Judge, at this time, we are looking to set for a preliminary examination date.
All right. Is all discovery complete?
Up to this point, as well as it can be, Judge. We just received a search warrant that they were going to be downloading some of Mr. Singh's electronics. I don't think that'll be ready anytime soon, so we're ready to set for the exam.
No objection.
Would people have their witnesses available on the 21st? Preliminary examination in person, January 21st, 2025. 9 a.m. before Judge Moore.
And Judge, Mr. Singh would like me to address his bond again briefly, if I could.
Yes, go ahead.
Judge, in addition to what I've argued previously, Mr. Singh has currently been in custody for about 45 days. He has no criminal history. He does have family here from India right now. They cannot stay for a long period of time due to the visa status. And he's also the sole member of his family who can provide in the United States. So I am asking for at least a bond reduction at this time, Judge.
Any response from the people?
First off, as Ms. Wisniewski argued last time, we would oppose any bond reductions at this time. This, as you remember, Your Honor, is an offense which the defendant is charged with 2 counts of criminal sexual conduct, 1 count of other counts that's great bodily harm, in which the defendant forced the victim to her apartment, slapped her in the face, refused to allow her to leave, threatening her, otherwise he would hurt her, took the victim into her car, smashed a plastic trash can on her head, and hit her with his hand until it was aching. Took the victim to the defendant's apartment and continued to assault her. We were hit clips, biting her, forced the victim to perform oral sex on him while filming it, and then threatened to send it to others. We would object any bond reductions at this time, given the severity of the charges and threats to the victim.
Motion for bond reductions denied at this time. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Jason Heron.
Assistant Public Defender Asli Bashir on behalf of Mr. Heron.
Oh, wow. Really? You didn't have to do all that other stuff. You wouldn't even come before me before. I know. But hey, what are we doing?
We are going to waive exam in both cases.
All right. Sir, is that a correct statement?
Yes, sir.
You're waiving your right to have a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have the hearing in either case and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 in both cases. Counsel, your turn. You acknowledge receipt of the information?
Yes.
You waive their reading?
Yes.
And line stands mute.
Yes, we stand.
Defendant having waived formal reading standing mute. Both cases, court will enter a not guilty plea. Pre-trial in these matters will be set for January 30th, 2025, 1:30 before Judge Sly.
Judge, I'll give you the notice when we leave. Yes, yeah, come on.
Bond will continue.
Come on.
She did. Up to. Court does call the case of the People versus Kristen Lucas.
Good morning, Your Honor. Hannah Mack on behalf of Ms. Lucas. To my right, please say your name.
Andrew Childers, attorney on behalf of.
All right, what are we doing?
Your Honor, at this time, we would like to waive this matter to circuit court.
Pardon?
We'd like to waive preliminary examination.
All right. Is that correct, Ms. Lucas? Yeah. All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses or the offense alleged was committed and that you committed it.
Yes.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
People also waive the right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
We acknowledge receipt of information, waive formal reading, and mute.
Defendant
My client will
waive
stand
formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
January 30th at 1:30 for Judge Slay.
January 30th, 2025, 1:30, Judge Slay.
Thank you, Your Honor.
Bond will continue. Thank you.
Yeah.
All right, you guys gotta clear out of there, yeah. Court does call the case of the people versus Ernesto Zuniga Alvarez.
Ashley Lonnie for the people.
Assistant Public Defender Ashley Bashir on behalf of Mr. Zuniga Alvarez.
Your name?
Ernesto Zuniga Alvarez.
All right,
Can we approach?
briefly, yes. Court calls the case, people versus Jamison Mitchell. When they get a chance.
Marshall, Assistant Public Defender on behalf of Mr. Mitchell.
Ashley Lonnie for the people.
Mr. Mitchell, petition for the record.
Jamison Mitchell.
Thank you, Your Honor. I did meet with my client. He's asking for a preliminary examination. I believe all discovery is complete.
On both cases?
That's my understanding, Judge.
All discovery is complete on both?
That's my understanding. Yes, Judge.
Okay. People have their witnesses available the 21st?
Yes, Your Honor.
Preliminary examination in person, January 21st, 2024. 9 a.m. That is before me on both cases. Bond will continue.
Couple days. All right. Thank you, Judge.
Thank you. Court does call the case of the people versus Kira Pinder.
Ashley Lonnie for the people.
Anna Mackey on behalf of Mr. Kinder, who's appearing to my right. Please state your name for the record.
Here, Pinder. Thank you. He's waiving exam. Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following.
Your Honor, we acknowledge receipt of information, waive formal reading, and my client will stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
January 21st at 1:30 for Judge Slay.
January 21st, 2025, 1:30, Judge Conkey.
Thank you, Your Honor.
Bond continue. Thank you. Ready? Court does call the case, people versus Melvin Reeves.
Stephanie Cannon on behalf of Mr. Reeves, who's appearing to my right. Mr. Reeves, can you please state your name for the record?
Melvin Tyrone.
Thank you, sir. What are we doing?
Your Honor, this is an adjourned PCC. My client is asking for a preliminary exam in this matter.
All discovery is complete.
Your Honor.
Provided this morning.
Pardon?
The last of it was provided this morning.
Got it.
Yes, we had conversations. The jail calls is what I was waiting on, and it's my understanding those have been provided to me, Your Honor. So we're asking for a preliminary exam. Your Honor, my client would also like to address bond when appropriate.
People, other witnesses available the 21st.
We'll do our best.
Preliminary examination, January 21st, 2025, 9 a.m. before Judge Moore as to bond.
Your Honor, my client is asking to be released on a PR bond, and if not a PR bond, he can be tethered to his phone. Your Honor, my client, the victim is actually written and given different explanations as to what happened that day. My client has always maintained he's innocent. He does not have to have contact with the complaining witness, does not want to have contact with the complaining witness. He is asking to be released. Your Honor, at the very minimum, if that is not what the court is inclined to do, he is asking to get his phone privileges back.
Your Honor, this is the case where we requested 250,000 cash or surety bond was set at 50,000, no 10%. The defendant, when this occurred, was in bench warrant status for a 2023 DV case with the same victim. I do think it's important to note that the reason we were waiting for jail calls is because he was contacting the victim while he was in custody. While I have not had an opportunity to listen to that, he had made 23 calls to the victim from when he was taken back into custody, which occurred, I believe, November 28th, between November 28th and December 19th is when those 23 calls occurred. So frankly, I'm concerned that anything the victim might be representing could have been influenced by her conversations with the defendant. Additionally, it's my understanding he has a bond denied hold from Allen PD. I'm not sure exactly what happened with the 14B case or what his bond is there, but presumably there would still be some implications. When we were here last, he, I believe, was held on a 10,000 cash or surety because he had been in bench warrant status and not picked up the same case. This is a home invasion first, but it's also a DV third with a tag along. In addition to all of that, this is something where the defendant appeared at the victim's home unannounced. The victim opened the door and found the defendant, and the defendant then pushed his way into her home and began assaulting her. The defendant then stole the victim's house keys. I'm concerned by the totality of the circumstances here. We asked for more and only got 50,000 with no 10% privilege. I don't think any further reduction is appropriate.
Motion for bond reductions denied. Bond will continue. Thank you. Court calls case People versus Robin Robinson.
Absolutely, people.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Robinson, who's approaching now. Robinson, please. Record.
Yes, Robin Robinson.
Thank you. Your Honor, we are waiting on some discovery. I believe that was sent over yesterday, so we did not to review the video.
Probable cause conference, January 23rd, 2025, 9 a.m. Bond continue.
Thank you.
Thank you.
What's up?
Court calls case People versus Brandon Smith.
People.
No.
Sorry. Let's say it's been a long day, but we're just starting. Mr. Smith, could you state your name for the record, please?
Brandon David Smith.
Judge, we're just asking for an adjournment in this matter.
Probable cause conference will be adjourned January 23rd, 2024, 9 a.m. Bond continue.
Thank you, Your Honor.
That's what it is. Court calls the case Beaver versus Antoine Taylor.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Taylor. Will you state your name for the record?
Antoine Taylor.
This is
All right, I have before me a plea form. Is that what we're doing?
just signing. And date. Yes, Your Honor.
Indicates that the defendant will be pleading no contest to the charge of assault and or assault and battery 93-day offense. Upon plea to that charge, count one would be dismissed. That is the court's full understanding.
That is correct. Thank you.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name.
Antoine Taylor. All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of assault and or assault and battery. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
All right. Do you understand what a no contest plea is?
Yeah.
Okay. Two things about it I have to make sure that you understand. First thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yeah.
Second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge and that you would be sentenced before Judge Barr in the 1482 District Court.
Yes.
Okay. Basis for the no contest plea.
Lack of memory, Your Honor.
All right. Understanding all of that, sir, do you still wish to plead no contest?
Yes.
And to that charge, how do you plead?
No contest.
All right. You understand that by pleading no contest, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form today. Is that correct?
Mm-hmm.
Yes.
Is that a yes?
Yes.
All right. Any questions regarding any of those rights?
No.
All right. Look at paragraph 5. There's a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yeah.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Mm-hmm.
And yes. Okay. And of your own free will?
Yes.
All right. Counsel, the court has been provided and has reviewed Ypsilanti Police Department report for their case number 2417267. Any objection to the court having reviewed that report?
None from the defense. Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could find the defendant guilty of the offense of assault and or assault and battery. Counsel, have I complied with the court?
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
January 22nd at 11 a.m. before Judge Barr.
January 22nd, 2025, 11 a.m. before Judge Barr. Welcome.
Thank you, Your Honor.
Thank you, sir. The court does call the case of the people versus Jemani Vanderloop.
Anna Mackey on behalf of Mr. Vanderloop, who is appearing to my right.
Bonnie Vanderloop.
Thank you.
Your Honor, at this time, we would like to set this matter for preliminary examination.
Both cases.
Yes.
Sir, discovery completing both of these matters?
It is, Your Honor.
All right.
That is not true. We don't have the 911 calls.
Oh,
They were requested, but we just have not received.
you
them.
haven't received them. If I put it out a week, we're gonna be able to get those, or?
Yes.
Probable cause conference, I'll adjourn out 1 week to the 16th, 2025, 9 a.m. on both matters.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Levante, Washington.
I said, objection, I think I can feel it, Your Honor, on behalf of Mr. Levante Washington. Approaching, Mr. Washington, state your name for the record, please.
Levante Washington.
Thank you. You're requesting an adjournment.
We are requesting an adjournment,
How
Your
much
Honor.
more time did you need?
I did not hear you, Judge.
How much more time did you need?
I think 2 weeks will be just fine, Judge.
Without objection, probable cause conference, January 23rd, 2025, 9 a.m. Bond continues.
That's the bond, Judge.
Oh, boy.
Yes.
Go ahead.
Your Honor, Mr. Washington was remanded at his last hearing because there was a positive test. He's asked that we address bond again today. I have made a number of contacts. I've reached out to his community corrections agent. She indicated to me that in order for him to get into CCOP while in custody, the court would need to send over an order to their attention so that they could at least start the process. However, he wouldn't be able to do the assessment until he's out of custody. So I guess our first request today would be that the court consider an order allowing him to enter the CCOP program so that he could be assessed. I also reached out to Matt Statman to see if he could come to the jail and do an assessment. I know that the court would like to see some type of plan in place to address his sobriety. He didn't want to address the court again today. He indicated that he wanted to take responsibility and be open and honest to the court and explain to the court exactly.
So what changed? Why does he now want to be open and honest?
I think primarily, Your Honor, he indicates that he was extremely shameful of what had happened. I think he could better say it in his own words. His family is here. He knows that he's let them down significantly over the past few years. I think this started back in 2023, right?
Yes, ma'am.
Yeah. So he knows that he's let them down and he just has not been very open with himself about the extent of his addiction. He and I had a great conversation. He has a lot of insight and he told me himself that he is not great with words, but he's going to do his absolute best to try and express himself to his honor so that he could see and understand where he is in regards to.
Is his mom and dad here?
They are. His mom is that your dad?
Mom and sister.
That's both
No,
of them.
no. This is my mom.
His mother is here, Your Honor.
What do you want to tell me?
First of all, I want to apologize for being dishonest with you. Like I say, whatever we can do to move forward and help me with the problem that I have, I just want to do the right thing, Your Honor. I'm not even going to lie to you. Like I said, I'm not the best with words. So
I'm understanding everything you're saying.
I know. I just asked for another chance. Honestly, I do.
Well, not funny, but why were you lying to me? I mean,
I was just in disbelief.
did I look like that stupid?
No.
Huh?
No, I was lying to myself, honestly.
Point. But you had lied to your mother about that, right?
Correct.
Right?
Yes, sir.
Because see, most people don't think I remember anything, but Mama was sitting on that side. All of a sudden, you may not have seen this, but all of a sudden, her baby was about to be in trouble. And Mom came all the way from that side over here. Because Mom was going to jump up and say anything she could to try to defend her child. Mom, am I right? And then the biggest disappointment was on her face because she couldn't defend you. So more than what you did to me, more than what you did to yourself, you did that to your mom. And I'm gonna tell you the way I am, that sometimes is a harder thing for me to forgive when you do that to your mom. Because I when I saw her coming over, I said, "Oh, what's she gonna do?" But because she was gonna battle for you. And that's who you really let down. You got me?
Yes, sir.
All right. So, Ms. Ecker, what kind of plan?
So, Your Honor.
I mean, I understand the CC. I get that part of it. But what kind of plan is in place for him so that I don't let him out of here and then next thing I know, I'm having to put him back in because he can't?
And Your Honor, I think that I spoke with Mom today, and I know he was on tether initially. And I think Mom, again, not realizing the extent of the issue, understood that he could not go, but people came to the house. And that's where his next level of exposure happened. And I told him, I said, the tether can keep you from going places and have them monitor you, but it obviously didn't stop you from testing positive. And he explained to me that it was due to influences that he had allowed back into his circle and his bubble. So what Mom has assured me of is that now that she knows that his access is not just based on him going out, she, with it being her house, is also going to limit or prevent anyone from coming in to see him, especially while he's in this very vulnerable state and until we can get him secured into some type of treatment. That was the commitment that Mom made to me today. I will say something too, Your Honor. When I had spoken with him, this is part of what I was expecting him to say to the court. I asked him, I said, so why did you lie? And he said, because my mom was there and I didn't want to tell her the truth. I wasn't here at that last hearing, so it is quite funny that the court is able to see exactly what the root of that particular situation was.
I could see it on Mom's face. I just didn't know who it was going to come at. I didn't know if it was going to be at me or what it was going to be at, but I could also see the hurt on her face. And young man, you got to do better.
Promise to. I promise I won't drop dirty again.
All right, here's what I'm going to do. At this juncture, secondarily, I'm going to, well, is there anything from the people?
We'll leave it in your discretion, Your Honor.
All right, here's what I'm going to do at this point. Secondarily, I'm going to deny the request right at this moment. I want in writing what is basically the plan.
Okay.
That it would be reinstated. He's not going to have folks coming over to his mother's house. Because, young man, how old are you?
24.
Yeah, she does not have to give you a home.
Mm-hmm.
You got that?
Yes, sir.
So I want that laid out. That this is what the defendant is going to do. I understand what Mom's going to do in terms of protecting her house. But I want what his commitment is in writing. So if he messes it up, it's his word. It's not something Mama didn't do. All right. And then I will consider, I'll look at that and based upon what we talked about, try to get him released. I want also in there the CCOP portion of that in the order. And then I'll look at and do that. Okay.
Okay, so we'll look at the order after we get you the plan.
You get us a plan and then you just prepare an order for these, but I want everything laid out, spelled out as to what he's going to do.
Understood, Your Honor. I'll work on that today.
You're not an amoeba. I'll have him look it up when he gets out as to why I'm saying it. He knows why I'm saying that.
Thank you.
I was just in the room and that's how I now go. Young man, You break that woman's heart. I don't know. There's a place in the jail, and you will just be staying there. Hear me?
Yes, sir. Appreciate you, Mark.
Thank you. Mom, you take care. You didn't think I saw you, but I saw you. All right. You're welcome. Court calls the case, People versus Douglas Wren. 3 cases.
Court shall feature Assistant Public Defender on behalf of Mr. Wren. Mr. Wren, please state your name for the record.
Douglas Allen Wren.
All right. You're still looking for an evaluation from drug court?
Yes, Judge. The court signed an order yesterday to have Mr. Wren released to inpatient treatment. That's going to take, that's a process of at least 30 days. He asked me yesterday when I saw him in custody to talk to the people about the possibility of a drug court evaluation. And so we're asking for an adjournment to seek their approval and get them evaluated.
How much time you?
If we can go 3 weeks, Your Honor, that'll at least look.
During these January 30th, 2025, 9 a.m.
Can I,
Sorry, Judge. Hold on, Mr. Wren. What date did you give Judge?
January 30th.
All right. Go ahead, Mr. Wren.
can Dawn Farms downtown, pick me up?
Judge already signed the order for your release to treatment.
Yeah, to release for treatment.
The Dawn Farm?
Well,
I think
it's a general release.
Yeah.
So whatever's going to be available first.
Okay.
Okay. I think I had already signed it. All right. Okay. Thank you, Bond. We'll
Sign it again. You already signed it. You're all good. Thank you, Judge.
Thank you. Be done, but here we go. Court calls the case, recalls the case, People versus Tariq Day.
Thank you.
Brian Bowling on behalf of Mr. Day. Can you state your name for the record, please?
Tariq Day.
Your Honor, thank you for.
What did Bellinger do?
It wasn't him. It was.
No, Bellinger gave him the wrong date, didn't he?
Yeah.
I was wondering why Mr. Day wasn't here.
He sent a bad email, Your Honor, with the wrong date.
That's what I'm thinking. And it wasn't your fault.
No, I know.
I know. It was Bellinger's fault.
We'll just ask you to recall the warrant, Your Honor.
I'll recall the warrant.
Then we would ask that this matter be set for preliminary examination.
Okay. And all discovery is complete.
It is correct. It is.
I was wondering where Mr. Day was. I was just like, okay. Oh, you pulled me a new form. Got it. People have their witnesses available the 21st, 28th. Any objection?
No objection.
Preliminary examination will be set January 28th, 2025, 9 a.m. in person. Judge Barr. Bond will continue.
For the record, Your Honor, I wrote January 28th, 2025 at 9 a.m. on this piece of paper that I gave to Mr. Day.
Okay, all right, very good. All right, Miss Day, take care.
Swear in the interpreter for the language.
You may.
Good morning, Madam Interpreter. Can you please turn on your camera, unmute, and raise your right hand to be sworn?
Ready, Judge.
Hold on.
Madam Interpreter, can you please unmute and turn on your camera?
Oh, thank you.
Oh, there she is.
Now you just need to unmute. If you're in front of a computer, you can hold down the space bar.
Okay.
There we go.
Can you please raise your right hand? Sworn.
Do you solemnly swear or affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Amharic and from Amharic into English in the manner now before the court to help you God?
I do.
Thank you.
All right. Good morning, Madam Interpreter.
Good morning. Excuse me. Sorry. Okay.
All right, you all set? Okay. Court does call the case of the people versus Medina Ishmael.
ፍርድ ቤቱ አሁን የሚጠራው መዲና እስማኤልን ነው።
Morgan Poisson for the people.
That was Morgan Poisson for the people.
ሞርጋን ኮስታን የሚባለው ደግሞ የህዝቡን ወክሎ የሚናገር
Portia Feaster, Assistant Public Defender, on behalf of Ms. Ishmael.
Can you repeat your name, please?
Feaster, Torshell Feaster.
Portia Esther የሚባለው ደግሞ የአንቺ ጠበቃ ነው። የህዝብ ጠበቃ ነው።
Ms. Ishmael, would you please state your name for the record?
እስማኤል ስምሽን ለፍርድ ቤቱ ተናገሪ።
እሺ
ስምሽ ማን ነው?
መዲና ነው። መዲና እስማኤል።
መዲና እስማኤል።
You're asking for an adjournment?
Oh, no, I'm sorry, Judge. She's asking for an exam. Ms. Ishmael is asking for a preliminary examination.
Did you interpret that, Madam Interpreter? That defendant is asking for a preliminary examination?
የምትጠይቀው የመጀመሪያ ችሎት እንዲደረግላት ነው።
እሺ
Okay.
Discovery is complete.
ግኝቱ ተጨርሷል። ጠይቀውሽ የሚገባውን ግኝት አግኝተዋል።
Yes, Your Honor.
አሁን ግኝቱ ተገኝቷል።
አልገባኝም።
ግኝት I don't understand.
Judge is asking me if I have all of the paperwork for your case.
ዳኛው የሚጠይቀኝ ሁሉንም የሚያስፈልገውን ጥያቄዎችና ወረቀቶች አግኝቻለሁ ወይ ብሎ ነው የጠየቀኝ።
Would the people have their witnesses available the 21st?
ፍርድ ቤቱ የሚያስፈልጉትን ሰዎች አግኝተዋል ወይ?
Can we please adjourn it out another week to ensure an interpreter is present for the victim?
She indicated, can we adjourn it out one more week so that we can have an interpreter available for the victim?
Do you need me to interpret that? የሚጠይቀው ያለው አንድ ሳምንት እንዲሰጠን ላንቺ የሚያስተረጉም ሰው እንዲገኝ።
አንድ ሳምንት
አንድ ሳምንት።
እሺ
What was that, Madam Interpreter?
To postpone the hearing for 1 week so there will be an interpreter for the client or for the defendant. Excuse me.
Preliminary examination will be set January 28th, 2025, 9 a.m. before Judge Washington.
የመጀመሪያ ችሎት የሚደረገው በጃንዋሪ ማለት በጥር 28 በፈረንጆች አቆጣጠር በጥር 28 2025 በ9 ሰዓት ማለት ጠዋት በ3 ሰዓት የፍርድ ቤቱ ዳኛ ደግሞ የሚሆነው ዋሽንግተን የሚባል ዳኛ ፊት ነው የሚሆነው።
ቆዞሮ አለ
ድገሚ።
ቆዞሮ ነው።
አዎ ቀጠሮ is it an appointment? So she is asking, is it for the appointment? For that day? Oh, I'm sorry. Go ahead.
Yes, that's her next court date.
የሚቀጥለው የፍርድ ቤት ቀንሽ ነው ይሄ።
Okay. Her bond will continue. Thank you.
Thank you, Judge.
የመያዣው ገንዘብ ይቀጥላል።
እሺ።
Okay.
Thank you, Judge.
Thank you.
አመሰግናለሁ።
Mr. Feaster. Thank you, Madam Interpreter.
Thank you, Judge. Thank you, Your Honor.
Yes, we can go off. Court does call the case of the people versus D'Angelo Green.
Yeah.
Echelon for the people.
Carl Burdell on behalf of Mr. Green. Good afternoon, Judge.
Good afternoon. Your name?
D'Angelo Green.
Thank you, sir.
So, Your Honor, I was just appointed late last night. At this time, I'm asking for an adjournment to the PCC. I have submitted the form to your staff.
Without objection, probable cause, January 23rd, 2025, 9 a.m.
Thank you, Judge.
Thank you. Bond will continue. Thank you, sir.
Thank you, Your Honor.
Court calls the case of the people versus Ian Edwards.
Assistant Public Defender Chelsea Ridgel with and on behalf of Ian Edwards. Mr. Edwards, please state your name.
Ian Edwards.
All right, thank you. All right, what are we doing?
Your Honor, we have a resolution. In this case, I have a plea form and a signed advice of rights form.
Oh, you have the plea form? All right.
Mr. Edwards would like to take the offer to plead guilty to assault and battery, dismissal of the felony with the understanding that he will be seeking HIDA.
Okay. And that's what the form represents, that he'll be pleading guilty to 93 days misdemeanor of assault and battery. That's the added count. 3 counts 1 and 2 would be dismissed, and that it is okay to seek HIDA. That's the court's full understanding.
That's correct, Your Honor.
Okay, having sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Ian Edwards.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of assault and or assault battery. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that, sir?
Yes, sir.
All right. The court also does have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, sir.
And so you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of them.
Yes, sir.
You understand you're giving up your right to appeal upright.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you in any way?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
On July 27, 2024, at the location of 601 West Stadium Boulevard, City of Ann Arbor, Washington County, State of Michigan, what do you do regarding a Jonathan Williams that makes you think that you're guilty?
I punched him in the eye, sir.
I'm sorry?
I punched him in the eye, sir.
Okay. And you did that intentionally?
Yes, sir.
And so you didn't have his permission to do that?
No, sir.
All right. Counsel, I think we have it.
Sufficient factual basis.
All right.
Defense is satisfied.
All right. Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 50th District Court probation. Sentencing will be February 6, 2025, 1:30 before Judge Balbo. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Thomas Ellis.
National Body for the People.
Why are you looking at her? Is it your case, Ballinger?
No, it's not my case.
Okay.
We're trying to find whose it is.
It is. Oh, and we were just talking about this. See, I knew it was not going to take all day for you to blow it. No, it wasn't going to take all. You. So everybody knows. I happened to see my good friend here during the break. I told her she had a good morning. That things seem to be going well for 2025. She said, Judge, I'm on it. I'm on it. I hear the first initial of the client called. I'm right there. Right? We come back from the break. First case with her on it. Can't find it.
I said black.
I made it clear she wasn't going to make it to February, but I know.
Half hour.
Yeah, right. I like it. He's gonna jump into your name, sir.
Thomas Ellis.
All right, thank you. All right, what are we doing now that you're here, counsel?
Now that I'm here, Your Honor, we would be requesting an adjournment. We wanted to put together some mitigation information for the people to review.
All right, how much time would you need to get that?
Can we do a month, Judge?
All right. Without objection.
Okay.
Probable cause conference will be February 6th, 2025, 9 a.m. or as your invite indicates, bond will continue.
Thank you so much, Your Honor.
Thank you. Thank you, Mr. Ellis. No, you do what you get. You go do what you got to do. Court calls the case. Bless you. People versus Ariane Ellie Dawson.
Morgan Puissant for the People.
Assistant Public Defender Ossie Bashir on behalf of Mr. Eli Dawson.
And sir, can you unmute and state your name, please?
Yes, can you hear me? Sorry.
Yes, we can hear you now.
Yeah, my name's Arian Ely Dawson.
All right. Okay. What are we doing?
We would like to set for exam.
All discovery is complete?
Yes, as far as we know.
Do people have their witnesses available the 21st?
Can we go out another week, Judge?
No. Yes, we will. You don't have any objection to that, do you, counsel?
No objection.
Preliminary examination, January 28th, 2025, 9 a.m. before Judge Barr. Bond will continue. That's in person. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Taiwan Griggs.
National for the People.
I spoke to Mr. Griggs. He has a guardian. He is incompetent, and right now he has been involuntarily committed. He is at Sacred Heart. I confirmed this with his guardian. I tried to confirm it with Sacred Heart, but they would neither confirm nor deny his presence. He did call me today. And in speaking to whoever was there beside him, they said they wouldn't let him do anything because he has a guardian, so they won't allow him to sign the release of information without her consent. Your Honor, I am simply asking for an adjournment of this matter so that I can get the release of information.
There's not a green sheet.
What?
Did you get a green sheet?
Yeah. What? No, but okay.
And Your Honor, I have no reason to doubt anything the defense counsel is saying. I will note to the record, though, it looks like we've had prior PCCs in this case, 10/31, 11/21, 12/26, and the defendant hasn't appeared for any of them.
Have you had communication with the guardian?
I spoke with her yesterday regarding getting the release of information. She was at work, which is how I'm assuming he was able to call me today because I sent her my business card and everything else. And so she is trying to get a release of information. She said when she calls that number that Sacred Heart has given her, it just rings. But again, she was at work at the time, so.
Well, I'll grant one more adjournment to the 23rd and try to get that at least solidified in some way.
Work for you?
January 23rd, 2025, 9 a.m. bond continue. Court calls case People versus Mohammed Haji Jelani.
Ashley Lonnie for the people.
On behalf of Mr. Haji Jelani, state your name for the record, please.
Jelani, good morning.
How are you, sir?
I'm good.
We're just asking this matter be set for an exam.
All discoveries.
It is.
People have their witnesses available the 21st.
We'll try, Your Honor. Thank you.
Preliminary examination in person, January 21st, 2025, 9 a.m. before me.
It's a Tuesday, like
Bond will
two
continue.
Tuesdays from now.
Thank you.
Thank you, Honor. Hope you have a good day.
You too.
Thanks, John.
Court calls the case People versus Mary O'Hearn.
Andrew Childers, attorney on behalf.
Assistant Public Defender Asli Bashir on behalf of Mr. Hearn.
Your name, sir?
Mario Hearn.
Thank you. You're requesting an adjournment.
Yes.
That objection, probable cause conference will be adjourned January 30th, 2025, 9 a.m. Bond will continue. Mr. Hearn?
Yes.
I heard you were surprised I was here.
Oh, yeah.
Right. I'm here all the time, so okay. Appreciate it. All right, you take care.
Thank you, Your Honor.
Court calls the case People versus Lonnie Howard.
Public Defender Hannah Apple appearing on behalf of Mr. Howard. Mr. Howard, will you please state your name for the record?
Lonnie Howard.
Your Honor, we're asking that this matter be set for a preliminary examination.
Discovery is complete.
To our knowledge, yes.
You have other witnesses available the 21st?
We'll do our best.
Okay. Preliminary examination, January 21st, 2024, 9 a.m. Quiet, Emily. That's before Judge Moore. Bond will continue.
Your Honor.
Court calls case People versus Phyllis Lynn Blake.
Ashley Lonnie.
Assistant Public Defender Jay Bellinger on behalf of Ms. Lynn Blade, who appears via Zoom, Your Honor.
Oh, there she
Your
is.
Honor, I'm Yvonne Davis, and I'm the guardian for Phyllis Blade. This is her.
Oh, okay, there she is. Okay, gotcha. Okay, thank you.
And Your Honor, I have requested an adjournment on this matter for reasons being that I have not been able to be in contact with Ms. Lindblade herself over the last couple of weeks. I did get in contact with Ms. Davis, the guardian. However, I need Ms. Lindblade's permission to sign her name to some certificates of release from the Humane Society. I can't get that permission from the legal guardian. I don't know if Ms. I'm sorry.
Say that again.
I cannot get legal. I can only get legal permission from Ms. Lindblade herself. I can't get it from the guardian in order to sign this paperwork. So I need Ms. Lindblade's permission in order to do that. That's
why.
That is our office policy, if nothing else.
And it's the surrender paperwork for her ownership rights in the animals, Your Honor. That's the paperwork.
But that's her legal guardian.
I understand, Your Honor. If nothing else, that is our office policy. I have been able to confirm that.
That's office policy that doesn't conform to the law, because if the guardian signs off, that's as if she is.
I understand, Your Honor. I just, because of that, I'm uncomfortable doing it. So I would need Ms. Lindblade's permission. She hasn't been, I've tried to contact Ms. Lindblade herself. I don't know if she has her phone available. I have a good number for her, but Ms.
Council approach, please.
Tell him my phone is lost.
Hold on.
I don't know that her legal guardianship has competence, Your Honor, just her medical.
Yeah, and how to document you covers the dossier.
All right, pretty much. Thank you.
So, Your Honor, I would propose that I speak with the guardian again on this matter. I would ask for a couple of weeks in order to do that.
Probable cause conference will be adjourned January 30th, 2025, 9 a.m.
Thank you.
All right, bond will continue.
Thank you.
Thank you, folks.
Thank you, Your Honor.
Thank you.
I can just see the phone to 2034.
People versus Sean Lutman.
Okay, Stephanie Cannon on behalf of Mr. Lutman, who is appearing by Zoom, Your Honor.
Mr. Lutman, can you state your name, please?
Sean Lutman.
All right.
Your Honor, the last time I checked, we were waiting on the 911 call that came in. Did you get it?
No, Your Honor, when we were last up on the 19th, defense requested 911, and I immediately sent an email over to state police requesting it. And yesterday, Ms. Cannon naturally asked if I'd received it, and I thought to myself, that's a great question. I sent an email over there. They apparently sent it, but I don't know how they sent it, and I don't have any record of it arriving in our system. So all I see was checking with the person at the Brighton Post that handles that. I was hopefully expecting an update by now, but I don't have it. The question was whether they sent it on a physical disk, which would be unlikely, or an evidence.com link. So it exists, it's out there. We just have to figure out where it is.
Got it.
We should be able to get it, though I don't see any reason why not.
All right, why don't I? 30th or 23rd, she think.
Your Honor, I mean, because he's asking for a preliminary exam, so do you need till the 30th?
I don't know if the judge is.
January 23rd, 2025, 9 a.m.
Thank you, Your Honor. Can we ask permission?
You guys went too long. What?
And that's perfectly fine, Your Honor. Can we ask permission for him to appear by Zoom? If you remember, he's paraplegic.
Absolutely.
Thank you.
All right. Thank you, sir.
Thank you. Goodbye.
Court calls case. People versus. Is it Dorinian Lee Marshall?
Public Defender Hannah Apple appearing on behalf of Mr. Marshall, who is approaching now. Mr. Marshall, will you please state your name for the record? Your Honor, there is some outstanding video and 911 call that we need to review, so I'd ask for an adjournment.
2 weeks be enough?
I believe so.
Probable cause conference, January 23rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you.
I'm going to give you this notice.
Court calls case of the people versus Nicolene Mason.
Ashalani to the people.
Brian Malloy, on behalf of Ms. Mason, Your Honor. She should be present on Zoom, Your Honor.
Hello, I'm here.
Yeah, you're here. All right. Hello, Miss Mason.
Judge Simpson, I'm not doing good. I had a seizure yesterday. Listen, I don't have internet right in my apartment, so I have to come across the street to my neighbor's apartment to use her internet. Anyway, after I got off with you, I didn't get on with Judge Perry. As I was going down the steps, I fell and had a seizure.
Oh my goodness. Okay.
So I'm 53 years old, so I ain't doing too good today. I'm hurting.
Okay. All right. We'll make this quick. But you got to Judge Perry yesterday, right?
No, I didn't. I'm going to get on it. As I was going to go dog on there, I fell down the steps and had a seizure. Literally, my neighbor right here.
Okay, so you didn't get over to that.
They had to help me.
Okay. If it at all is helpful with that, have her call me and I'll tell her you showed up for both your hearings before me. So, all right.
So what I'm going to do is I'm going to call the number on this letter that I got the other day from her court and find out what day I can come or whatever.
Okay.
Okay.
All right.
I'm going to take care of it though. I'm not trying to elude or avoid anything.
Miss Mason, I know you're not. Yeah. And Miss Mason, you make sure to do that. I'm going to have my staff email Judge Perry's staff to let her know that you were before me on that date, so that if that helps you out at all, okay?
Thank you, sir.
All right. All right.
But we get an exam date. All discovery is.
You want an exam date on this?
Yes, please.
Okay. All right. So all discovery is complete.
Yes, sir.
People have their witnesses available the 21st.
Jared, can we please go one additional week?
No objection.
Preliminary examination. Pardon?
I was saying we don't need no witnesses. I am definitely, but I'm accused of.
You don't need any witnesses?
No, sir. I did what they said.
Miss Mason, hold on, Miss Mason. Miss Mason, hold on.
Okay.
Hold on. Well, you let your attorneys handle that part, okay?
Okay, sir.
Okay. Just put your.
Okay, sir.
Just trust them, okay?
Okay.
If they think that the people should bring their witnesses, just go with it.
Okay.
Okay. January 28th, 2025 at 9 a.m. before Judge Washington.
Okay. So do I go Zoom or do I come in person?
You got to come in person on that date.
Okay, so where is that at? In your courthouse?
Yes, it's in the same courthouse I'm in. There'll be different judges up here, but it's the same place.
Okay. Well, my attorney, he can hear me, right? Just make sure you let me know, remind me and stuff, so I can make sure I got up here.
Okay. All right. Yeah. Make sure you let her know. You hear that?
I will.
Yes.
All right. Because Miss Mason has spoken. All right, Miss Mason, you take care.
You too. Thank you, Judge Simpson. I appreciate you so much.
Yes, ma'am.
Thanks, Judge.
You have a blessed day.
Court calls the case, People versus Jacob Miller.
Any for the people?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Miller, who's approaching now. Right up here. Will you please state your name for the record?
Jacob Miller.
Thank you. Your Honor, my understanding is that there is take your hands out. That there is a referral for competency that should be in the file.
Yes.
We're asking that the court sign that order and then set out a
competency hearing date.
Yes.
All right. A forensic evaluation is ordered. Set a competency hearing date out. April 10th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
You're all set.
Court calls case People versus Cody Moore.
Assistant Public Defender Shanaza Ikeri Akinruli, Your Honor, on behalf of,
Back on track.
I'm back on track. On behalf of Cody Moore, Judge.
Your name, sir?
Cody Moore.
All right.
We respectfully request to set this matter for preliminary examination,
All discovery is complete.
to my knowledge, Judge.
And would the people have their witnesses available the 21st?
Your Honor, can we go one more day out? This will require a witness from the parole office. I don't know if she's available on that day. Actually, she is available on that day. We can do that day.
What's the date?
21st.
Thank you, Your Honor.
Preliminary examination in person, January 21st, 2025, 9 a.m. That is before Judge. Oh.
It's
before me. Didn't mean to say it that way. Bond will continue.
Thank you, Your Honor. Yes.
Thank you, Your Honor.
Thank you, sir. Court calls the case People versus Taisha Morgan.
Thank you.
Ready, Judge. Court show feature Assistant Public Defender on behalf of Ms. Morgan. I'm told she's on Zoom.
Well, her name's there. Ms. Morgan?
Yes,
Okay, there she is. State your name.
Aisha Morgan.
Okay.
Thank you, Judge. It looks like Ms. Morgan was communicating with a different attorney in my office and not myself, so I have not spoken to her. So I need an adjournment so that we can.
So what'd the other attorney say? Never mind. That's privilege.
Yes, sir.
Okay.
So I apologize. We can get a brief adjournment, Judge. Hopefully Ms. Morgan and I can connect.
January 23rd, 2025, 9 a.m. Bond continued.
Thank you, Judge. I'll call you, Ms. Morgan.
Okay.
All right. Take care, Ms. Morgan.
You too. Bye-bye.
Court does call the case People versus Thurman Pool.
Andrew Childers, appearing on behalf of.
Assistant Public Defender Shanaza Ikeri Akinruli, Your Honor, on behalf of Mr. Thurman Poole.
Your name? Thurman Pool. Thank you.
Judge, we're asking for an adjournment in this matter.
Of course, you. How much time do you need? 2
3
weeks
weeks
to
is
work?
fine. Yes, Judge. Thank you.
Probable cause conference, January 23rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case People versus, is it Yair Sanchez Ortega?
Absolutely, for people.
Brian Mulling on behalf of Mr. Sanchez Ortega.
Sir, can you state your name, please?
Yair Sanchez Ortega.
Thank you.
We're asking for an exam. Discovery is complete.
People have their witnesses available the 21st?
Okay, Your Honor. We'll try for that date, Your Honor.
Preliminary examination in person, January 21st, 2025, 9 a.m. before Judge Moore. Bond continued.
Thank you, Your Honor.
Thank you.
Court calls case People versus Patsy Shear.
Morgan Poisson for the people.
Assistant Public Defender Chelsea Virgil with and on behalf of Patsy Shear, who appears via Zoom. Ms. Shear, please state your name.
Patsy Shear.
And you're requesting an adjournment?
Yes, Your Honor.
Other, gotcha.
We've reached a global in this matter, so for the defendant to avail herself of the plea in this case needs to be first. That is up. I'm sorry, when is the next?
Your Honor, that's on the 16th. We would ask if you don't mind, could she please have her probable cause conference also on the 16th to resolve both cases that day?
Say again?
The 16th is her pretrial in the other case. she has to plead on that first. We're asking for you to set the probable cause conference also on that date.
What time is her hearing on the 16th and where?
It's at 9 a.m. I believe it will be here.
It's in front of Judge Freshour.
Ah, got it. Okay. Okay, I'll adjourn it out a week under those circumstances. January 16th, 2025, 9 a.m.
Thank you.
Bond continue.
I'm sorry, may I address the bond conditions?
You want bonds? She's out.
Well, I would like to keep the personal bond if possible, but the conditions I would like to address.
Oh, so now you're getting nitpicky. Go ahead.
Your Honor, we have two humble requests for you today. We ask you to consider first allowing her to do drug and alcohol testing at Dawn Farm, where she resides. She's in transitional housing, which I provided paperwork to show.
Do the people have any problem with that, provided there's a release?
No.
All right, then you can prepare a stipulated order to that issue. What's your next one?
We are asking again for you to consider consensual contact. Her family has expressed to me, she has an aunt, she has a supportive family, and both her and her family have expressed to me that it's difficult for the kids to have their parents not have contact. They've always been raised together. So just to continue raising their family together, we're asking for consensual contact. Ms. Shear has, I believe, behaved exemplary well on bond. I understand there was an instance of contact, but aside from that, she has been really dedicated to improving herself, completing her treatment at inpatient home of New Vision and now at Dawn Farm, with both mental health and sobriety, really committed to improving herself. And I ask you to consider just consensual contact.
I don't think it's appropriate at this time. If this case was picked up while another case was pending, and then there was, I'm sure as the court remembers,
yes,
the contact violation. I'm very glad to see that Ms. Shear is taking her treatment seriously. It seems like it's going well. This seems like there's going to be a resolution in just a couple of weeks. I would like to get to that point and have it be solidified, have her continue to earn that resolution. I understand it's difficult for the children, but at this time, given the history of this case, I just think it's a bit premature.
And the court would agree. So what I'm going to do is I will grant your request for a change as to the drug testing issue. I will deny it as to the no contact provision.
Okay, thank you.
Right. Thank you.
Thank you.
Court calls case People versus Eric Smith.
And with no behalf of people. And I'm going to
Who is approaching? Please state your name for the record, Mr. Smith.
Eric Smith. Thank you. You're asking for an adjournment.
Yes, Your Honor. 3 weeks, if possible.
That objection, probable cause January 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
That works.
Okay. Court calls case People versus Deion Stanley.
Ashley Long for the people. Assistant Public Defender Chinazi Kyriakin, really on behalf of Mr. Deion Stanley, who is approaching. Mr. Stanley, when you get here, could you state your name for the record, please?
Deion Stanley.
Thank you.
Judge, we request that this matter be set for.
I wanted to adjust the, can I adjust the court? Can I say something?
It all depends on what you're going to say.
Oh, I've been, my papers told me to be here at 9 o'clock on the dot. I was here at 9 o'clock on the dot. My paper said be here at 9. And I went to my job first and told my boss I had court at 9. And I've been here at 9.
but you get placed into a block.
Yeah. And
Right.
not-
Everything is set at 9. You get placed into a block. Your attorneys send out communication to you as to what the time is.
And then, you know.
And I think the issue, Your Honor, is that Mr. Stanley maybe did not receive the information as to what time his block was going to be. So he did appear here at 9 o'clock. He and I had spoken earlier, and he was a bit discouraged when I did tell him that his block was at 12:30, and at that point, it didn't make sense for him to leave. So he's just a little frustrated that he's been here since 9 o'clock.
And I told my boss I was gonna be back at 12, and now I'm about to just miss a whole day of work. He gave me the opportunity to work a half a day.
Okay, but I know the communication would have gone to your email address by the public defender's office. So I understand what you're saying. I don't know what you want the court to do about that, because it's not as though they didn't do what they.
I'm just saying, I seen people come in late, get seen, and you even said that you came in late. I don't know. Maybe I haven't been in trouble in 20 years, so I don't.
Okay, so but I don't know what you want me to do.
I think he's just more so expressing some frustration to the court. There is no remedy for
I
that.
understand that.
Yeah.
There isn't a remedy for it. The only thing I can tell you is that I know that everything gets set basically by me at 9 or at 3, technically. And so the thing is that you've got to keep on top of your communication from your attorney's office, because they tell you what time block you end up in. So what are you asking to have? You want a preliminary?
That is correct, Your Honor.
All discoveries complete?
So our understanding,
And would the people have their witnesses available? And the 21st?
Checking, Your Honor. Now, we just go to 28.
Preliminary examination in person, January 28th, without objection. 2025, 9 a.m. in person before Judge Barr. Bond will continue. Thank you.
thank you, Your Honor.
Court calls case People versus Robert Suggs.
The judge.
Could you state your name for the record, Mr. Suggs? You got to speak up for the judge, okay?
Robert Suggs. Thank you, sir.
Your Honor, my client is asking to exercise his right to a preliminary exam in this matter.
All right.
To my knowledge, all discovery is complete.
People have their witnesses available the 21st.
We'll try, Your Honor.
Mr. Suggs, I'm going to set your preliminary examination in person, January 21st, 2025, 9 a.m. before me. Okay,
So we'll be back on the 21st.
21st. Okay, sir.
Okay, Mr. Suggs, we're all set.
Okay, thank you, sir.
Mr. Suggs, we're all set. We're all set.
Thank you. Thank you, sir. I notice your patch there. Are you military?
Are you in the military, Mr. Suggs? Were you?
Which branch?
Which branch? 96 Marine Corps, Your Honor.
God bless you. Thank you for your service, sir.
22 years.
Long time. Long time. Court calls the case, People versus William Sumler.
Assistant Public Defender Chelsea Richfield with and on behalf of William Sumler, who appears via Zoom. Mr. Summer, please state your name.
William Sumler.
All right, I have before me a plea form that indicates that the defendant will be pleading no contest to attempted larceny, 200 to 1,000. That is a misdemeanor punishable by up to 6 months incarceration. Upon a successful plea to that charge, the felony would be dismissed. There is an agreement also to no delayed or deferred, although I cannot find the sentencing court.
That is correct.
All right. Is that a correct statement, counsel?
Yes, Your Honor.
All right, very good. Sumler, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. State your name again for the record, please.
William Sumler.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of attempted larceny, 200 to 1,000. That is a misdemeanor punishable by up to 6 months incarceration and or a $1,000 fine plus court costs. Do you understand that?
Yes.
All right. You understand what a no contest plea is, sir?
Not exactly.
Okay. A no contest plea, first of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
All right. Second thing that you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty to the charge. You understand that?
Yes.
All right. The other thing is that the court has been provided and has reviewed a police report in this case. I would be taking those facts as true to determine whether or not there was a crime that was committed and that you committed that crime. You understand that?
Yes, sir.
Okay. Do you have any other questions about a no contest plea?
I don't, because I don't want to make my attorney look bad. But I didn't do anything.
Oh, hold on. All right.
And
Mr. Sumler, hold it. I don't think you're necessarily.
I don't want to do no time in jail. Like I didn't do nothing to do no
Okay,
jail.
Mr. Sumler, stop.
Okay.
Stop for a moment. Okay. Here's what I'm going to do because I think you need to have sometimes cases, regrettably or beneficially, are about getting somebody to a safe spot. So you're not making your attorney look bad. You're not doing anything. If you don't want to plead or you're unsure about something, then my job is to try to make sure that you are sure about what you're doing. So what I'm going to do at this point is I'm going to stop this plea. I'm not going to take the plea. I'm going to adjourn this out a couple weeks, let you talk in detail, get all questions that you want to ask your attorney so you understand exactly what you're doing and why.
Right, because my thing is, Your Honor.
Because no, I don't need your point. That's what we're doing. I don't want you to say anything that may incriminate you in any way. I just don't want you to say anything. Based
Yes, sir.
upon what you've already said, this is what I'm going to do. Okay? And then I want the next words that come out of your mouth, other than say, thank you, we'll see you in 2 weeks, should be said to your attorney. You hear me?
Yes, sir.
Probable cause conference in this matter will be adjourned to January 23rd, 2025 at 9. Or as your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your
Thank
Honor.
you, Mr. Sumler. We'll see you in 2 weeks.
Thank you. You have a good one.
You too. Court calls the case, People versus Cynthia Settle.
Absolutely for the people. Public Defender Chinazi Carey, I can rule, Your Honor, on behalf of Ms. Settle, state your name for the record. Judge, we are, did I put a green?
What's wrong? I have it. You don't even know what you're doing now, do you? You're operating so fast and on time, you have no clue what you've done and what you haven't done. Isn't that right, Ms. Eckenberg? You just,
We are requesting an adjournment, Your Honor. We would like to ask that the court enter an order. There are restitution payments that need to be made on this in order to get the offer from the people. She did try and make the payment, but she was told by the desk at that they need an order.
and they, go ahead. Oh, we can't take the payments here. So we can't take them at this location.
Okay.
So she'll have to pay downtown.
At the circuit court.
15.
Okay.
But I can, no, not at circuit court, at 15th district court.
Okay.
Is there, and I'll write this on it, but how much is she going to pay total?
Right.
What we'll do is $2,800.
So the payment that she wants to make today, Your Honor, is the 8.
I'll make the 28.
Okay, the entire payment, Your Honor.
Today?
She was ready to pay it today, and she went.
She was ready to pay $2,800.
You know, and they rejected
our
it.
clerks didn't?
They turned her away. Yeah.
Okay.
How much? 30 days.
So what I'm going to do is I will indicate on this form that defendant may pay up to $2,800 in bond to be held as restitution. And so I put that on here, and then hopefully when you go downtown, they'll take the funds. All right. How much time did you want me to turn this out for?
She's requesting 30 days only because she has to give 30-day notice to her job for taking time off.
Do you have to do that?
You know, I can't.
No.
I don't even know how to request
You don't even
time.
know how, I know you don't know how to respond.
And
You need 30 days
it
to.
would be nice because we've been.
Yes, sir. So if I gave you till February 6th, would that work?
Yeah.
That will work for, okay. Probably without objection, probable cause will be on February 6th, 2025, 9 a.m. Bond will continue. You're welcome.
Thank you so much, Your Honor.
It's good to see, Ms. Akinrule, that you are seated first at the table. So just in case, huh?
Hearing on behalf of defendant Cynthia Berger, who is standing to my right, Your Honor.
So, Your Honor, interestingly enough, I was reviewing everything with Ms. Girding before the docket, and we were Ms. Romberger has a case pending in Jackson, misdemeanor, and I was curious as to why she had a misdemeanor felony here. In so doing, I discovered that one of the priors that we used to enhance this was actually nollie-cross. So this case correctly charges felony, and it should be an OWI second. My question to the court for today's proceedings are, if the court wishes to just remand it now, in knowing that I will file an amended complaint, or I can have an amended complaint filed with the court. We come back in a couple of weeks, and then it gets remanded once we have that amended complaint by second as the charged offense.
Do you have a preference? Counsel?
Your Honor, if we could just remand it so there's one last court hearing, that would be great.
Yeah, I don't see why we just don't remand it down to 1484.
I do not have.
All right. There's an OWI second.
There is a 2022 2/4/2022 in Jackson conviction as it's listed as an enhancement. That is the one that was nollie crossed with the 9/19/23 conviction.
So the 23 is the valid
Yes. Yep.
conviction. Gotcha. How that actually is going to look is that the Smiths count 1, right? And then remanded on what really is going to effectively be a count 2. That sounds funny, but that's the way it's going to work, which is an OWI second offense. The defendant's plea of not guilty will be maintained. I'll set a pretrial. Do we have a pretrial date for Judge Simpson? January 28th, 2025, 9 a.m. You said? 10 a.m. And that would be before Judge Freshour. All right. Her bond with its conditions, however, at this stage will continue.
Can I address something with the court regarding her testing? Miss Romberger lives out of Jackson. Currently, she's testing here in Washington. We were wondering if she could be able to test in Jackson.
She could test. You can prepare an order to that effect. Actually, at this point, we need to be signed by Judge Freshour.
Okay.
That she can test in Jackson, but part of that order, at least for me, is that there be a release of information to send the information to community corrections.
Okay, thank you.
All right. Okay. Thank you.
Your Honor. Have a
Good stuff. Court calls the case of the People versus Isaiah Adams.
Good afternoon, Your Honor. Amy Rides on behalf of the people.
Afternoon, Your Honor. Dan Guerin on behalf of Isaiah Adams.
Your name, sir?
Isaiah Adams.
Thank you.
Your Honor,
go ahead.
Your Honor, we're asking for an adjourned probable cause conference to the 30th, and may Mrs. Reiser and I approach very briefly. Very, very briefly. Or just me.
Miss Reiser can. No, come on. I will adjourn probable cause then in this matter, January 30th, 2025, 9 a.m. Urge your invite indicates. Bond will continue. There was a request for a modification or condition thing on bond off of the record. As I've indicated, Mr. Guerin can explain it to his client. I'm going to deny any request or change.
Understand, Your Honor. Thank you very much. I'll explain that to Mr. Adams.
All right.
I'll meet you guys.
Thank you. Court calls case People versus Natalie Guzman.
Andrew Kulik, appearing on behalf of the people.
Afternoon, Your Honor. Dan Guerin on behalf of Natalie Guzman. She's stepping forward.
Your name, ma'am?
Natalie Guzman.
Okay. And I have before me a plea form. Indicates she's going to be pleading no contest to the charge of larceny less than 293 day offense. On her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. And if it's a no contest plea, counsel, I don't.
Your Honor, in my right hand, I'm giving that to Deputy Allen.
Okay.
I'm sorry I didn't get that to you sooner. We just worked out the mechanics of that this afternoon.
Okay, I got it.
Yeah.
No, it's okay. I'll get
a pretty easy, quick read.
Is it? Okay.
Yes.
All right. So that's the court. That's the people's understanding also.
Yes, Your Honor.
All right. Very good. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God. State your name.
Natalie Guzman.
All right. Ma'am, it is this court's understanding that you're going to be pleading no contest to the charge of larceny less than 200. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased 3 times the value of the property taken. If that's greater than $500, that could become the maximum fine. Do you understand that?
Yes, Your Honor.
Okay. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things I will explain to you is that it first of all means that you're not desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
All right. Second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea?
Our lack of memory.
All right. Ma'am, to this charge of larceny less than 200, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of right form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of rank.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
No, you're on bond conditions.
Oh, I'm on bond. Your Honor.
Okay, so you're not on probation or parole.
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes.
and of your own free will.
Yes, Your Honor.
The court has been provided and is reviewing or has reviewed Ann Arbor Police Department report for their case number 24-57223. Any objections to the court having reviewed that report?
Okay. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be February 6, 2025, 1:30 before Judge Valvo.
Your Honor, unfortunately, I have a travel request at the appropriate time. If there's an appropriate time.
No, you can go. There never is an appropriate time for you, Karen, but go ahead.
Your Honor, my client has previously been given permission by Your Honor to leave the state, but she needs to go, is asking to go again, this time for a work trip in Hawaii.
Right.
Yes.
No, I'm sorry. Sure.
Actually,
it's a work trip.
Your Honor, the event's start date, why don't you tell them the dates of proposed travel?
January 17th and return, I believe, on the 23rd.
A week in Hawaii for work. In January.
Not a bad deal.
Exactly.
I printed.
No, he's
I had
right.
a
No,
feeling.
ma'am, I believe you.
He's gonna have to take the court.
Yeah, that's right. We're all apparently going to Hawaii to handle this hearing. I'm sitting on that date. Counselor, if you just send me an order, I'll sign off on it.
I will, but we have one. She's been testing all clean. Is it possible she does an ETG when she returns or some sort of alternative?
Any objection to that?
Okay.
All right, put that in the order.
Will do.
And get that over to me as soon as you possibly
can. Get this afternoon. Thank you, Your Honor.
All right. Thank you.
Thank you.
Bond will continue in
Great.
all other aspects. And ma'am, Godspeed to you on your travels.
Thanks, Your Honor.
I'm supposed to go to work at Tahiti. Court calls the case People versus Devin Morgan.
Andrew Chill is appearing on behalf.
Good afternoon, Your Honor. Allison Castles, Guerin Law Group, on behalf of Devin Morgan.
Your name?
Devin Morgan.
Hold it. Just a minute. He left the room.
I know.
I was left unsupervised.
I know. It's like so cool, right?
Yeah.
I actually yelled at him about it. I told him he didn't just let her go. Just let her
worked.
No, that's good. Let's start doing something crazy so that we can think, what the heck? And no, go ahead.
All right. If you make something up, I'll go with it. All right, we're just going to ask to adjourn out for another 3 weeks to allow for ongoing.
She was fine. All right. He's coming back in checking. Go ahead.
We would just ask to adjourn out another 3 weeks to allow for ongoing discussion with prosecutors.
Okay, 3 weeks is that any objection from the people? All right. Probable cause conference, January 30th, 2025, 9 a.m.
Thank you.
Bond will continue. Thank you, ma'am. Let's call the case of the people versus Earl Carver.
And that's on behalf of the people.
Alice Friedman for Earl Carver, he's present. Mr. Carver, would you stand here to my right, please?
Your name, sir?
Earl Carver.
All right.
Your Honor, I was just recently retained on this. I got the police report yesterday. I'd ask for 3 weeks on this, and then I do want to address bond.
Okay. Without objection, probable cause conference, January 30th, 2025, 9 a.m. Yes, that's the bond.
Would that be 9 a.m.?
Pardon?
That'd be 9 a.m.?
Yes, 9 a.m.
Okay.
Kind of.
Yeah.
Or as your invite indicates.
Okay. In this case, Your Honor, there was a bond that was issued. Bond was that was issued was no contact, which doesn't for the Carvers. They have a family business together. They have a construction company together, and they're landlords together, and they have to communicate. We are willing to stipulate to email and text message contact. We can live with that. I don't think he can do much in the way of threatening or harassing if there's a written record of emails and texts. And then as far as living is concerned, he was barred from both their properties. They have a family house in Manchester and a cottage in Irish Hills. Mrs. Carver would prefer that she go to the cottage in Irish Hills and he take the family house in Manchester because there's livestock that he takes care of.
So which is it, the Keys one that you want to be at?
Yes.
That's the one. Okay. Anything from the people on this?
Your Honor, as to the changing the no go to, we would be amenable to that. However, we prefer to do that through stipulation to ensure there's no overlap of contact between the two parties. And then as to the no contact, we would be opposed given the facts of this case and some of the answers that were given, the look value assessment. We would be opposed to any contact between the parties.
Okay, but I think what Mr. Friedman is in part asking is that any contact, that not to entirely lift the no contact, but that it be by email and text.
Correct.
We would still be opposed to that, Your Honor, given the facts of the case.
All right, here's what I'm going to do on this, given the circumstances of this particular case, is I will modify the no contact provision. No contact will remain in place, but consensual contact only by email and text.
Your Honor,
Regarding the family business and, well, regarding the family business, which also includes the rental properties, right? I mean, that's all a family business.
Yes, sir. Rental properties and the construction company.
Yes. So that would have to be specifically laid out. So consensual contact only as to those things.
Yep.
All right.
Need this.
Back on the Carver matter. What were you saying?
I just wanted to clarify that the no go to would remain in place until we had confirmation that Miss Carver was out of the marital home and in the cottage, and then we would modify no go to through a stip.
Well, I think I don't have any problems with that procedure, but there are two addresses. And so my understanding is that, do we know which one she preferred? Because we had basically said he was going to be at the Keys address.
Yes, we do know she's here and to express.
Oh, she's here. Oh,
she expressed it to the advocate. She's right there.
So are you out of that one property, ma'am?
Which is why I want a confirmation that should be out of the.
I'll leave the house before she's back. Yes.
Okay. So that I'm clear. Mr. Carver is going to reside at the Keys Road address. The other address, Mrs. Carver will be residing at. The Edwin? Okay. So, and ma'am, that arrangement where he would be residing there, that's acceptable to you? Okay. She has acknowledged that, so I don't know that. I think the order can just go through as is, since she's here. Okay? All right.
Thank you.
Thank you. Court does call the case of the People versus Rakesh Sabharwal. Sabharwal?
Echelon of people.
I probably messed that up, but I did what I could.
Good afternoon, Your Honor. Kenneth Thompson appearing on behalf of Rakesh Sabharwal, who stands to my right. Rakesh, could you say your name for the record?
Rakesh Sabharwal.
That's exactly what I said. All right.
That's what I heard.
Okay, you're requesting an adjournment?
That's correct, Judge. And
all right, how much more time did you need?
a couple of weeks, I believe. Would be
2 weeks?
Yeah.
All right. Probable cause conference, January 23rd, 2025, 9 a.m., or as your invite indicates.
And Judge, could I address bond briefly?
Sure.
Might be a little premature, but my client has a pre-planned family vacation, a cruise coming up in April. I think this case is going to be over by then, but he has a few days to cancel that to receive his deposit back. I do have.
Where is it? Where is it to?
He will be traveling to Rome, and the cruise leaves from.
I am apparently doing something very wrong. I got Hawaii. I got Rome. I'm going to Southern Pittsfield. I just go ahead. I'm sorry.
And for the judge, you could tailor the order how you like.
That's true. I could.
I mean, but
is there going to be any objection from the people in terms of those dates?
No, Your Honor, I did let defense counsel know that this person may already be on probation by that point, so I don't have an issue with it as a bond condition, but if we get to the place where we're done with the plea and all of these sorts of things, it may need to be addressed with probation, so.
Right.
I just don't want him to think the probation will continue.
Understood. Yeah. Understood. Yep. So, counsel, if you prepare an order to that effect at this point, and
as a bond,
that might as a bond, and then that way maybe it might be a little bit easier if you get to that point. Okay.
Understood.
All right. So, at this point, bond continued. Prepare that, and I'll sign off.
Thank you very much, Judge.
All right.
Good to see you, Your Honor.
Good seeing you. You guys take care.
Thank you, Your Honor.
Court calls the case of the People versus Matthew Gingras. Gingras?
Yes. We're on Zoom. Good afternoon, Your Honor. Jeffrey Abood appearing on Zoom on behalf of Matthew Gingras, who's also present via Zoom. Also present are attorneys Matthew Tabby and Angela Kaminsky from the Abood Law Firm. I appreciate you allowing us to do this Zoom this afternoon. I'm actually in the Huron County Circuit Court for a trial and stepped out, and that's why my associates are on just in case I wasn't able to step out.
Oh, okay. I thought you just brought troops with you or something. I don't know. I didn't know what was going to happen. Okay. And what are we doing? And your client is here? Could you state your name, please, sir?
Matthew Gingras, Your Honor.
All righty. Thank you. What are we doing today?
Is the prosecutor in the courtroom at all? Is there any way I could talk to him? I believe it was Mr.
There's like a whole herd of them.
All right. Well,
This is Andrew Childers. I'm here on the case. Jeff, how are you?
Oh, you're handling it. Good. How are you?
Good.
Good. Is there any way we can?
Glad we can have a reunion. And by the way, when you just said, I'm glad he's handling it, you just insulted about 5 other prosecutors. But that's okay, counsel.
Who said
Don't
I'm
worry
glad?
about it. When you come back, welcome back.
I said, oh, you're handling it. I didn't say I'm glad he's handling it, but
Okay. Well, I'm just telling you how it was taken. So
may I have a breakout room with Mr. Childers? Or Mr. Childers, you want to talk? Can we talk about this on the phone?
First of all, I don't do breakout rooms. I will adjourn it out so you guys can talk in the interim and see what you can work out.
That's great. Thank you. I'd love to.
I will, I'll shoot you a message with my email with my contact, my cell number, and you can give me a call, okay?
Thank you. And then, Judge, as far as it,
I was going to put it on the 23rd or the 30th, but I only want your associates here. I want a day you're not available. No, I'm kidding. I'm just doing that for the prosecutors.
Well, guess what, Judge? I was going to address I'm not available on either day because the trial I'm in right now in Huron County, those are both return dates. So I was going to ask for a date in early February, if that's okay. I am in this trial through the rest of the month.
Do you have any problem with that? Well, will February 6th work for you, counsel?
I'm going to look, but I'm assuming yes. And if not, we'll make the judge happy and send my associates. So February 6th. Ooh.
13th?
That's third. Okay. February 6th, hopefully we'll all be in New Orleans for the Super Bowl. February 13th.
Oh, no. See, that's it. That's it. I got Hawaii, Rome. Somebody's going to New Orleans. That's it. No, not letting anybody go. I'm setting.
We're going to the Super Bowl, Judge.
Okay, we'll go to the Super Bowl. We'll go to the Super Bowl.
But Judge, listen, I do have clients that might be playing in it, so I might have to be there. But February 13th is perfect.
Okay.
And hopefully we reach a resolution sooner, and if we do, we'll let you know. So.
All right. February 13th, 2025, 9 a.m. or as your invite indicates, bond will continue. All right.
Thank you, Judge. Nice to see you. Appreciate it.
Good seeing you too, sir. If somebody else says they're going someplace, that's it. No, I don't tell people where I go. Court calls the case, People versus Emma Mathis.
Good afternoon, Judge Larry Margolis on behalf of Emma Mathis. Ms. Mathis, please state your name.
Emma Mathis.
Thank you, ma'am. All right, what are we doing?
I'm hopeful that we're working toward a resolution. Ms. Londi has advised she would like to speak with the complaining witnesses, the officers, before we have a resolution. So I would defer to Ms. Londi as to the length of time she would like to do that. I'd be requesting the adjournment.
Well, a couple weeks do it, Ms. Londi. Probable cause conference will be adjourned January 23rd, 2025, 9 a.m. Bond will continue. Thank you.
Judge.
Court calls the case, People versus John Lee McHugh.
Lawrence Margolis on behalf of Mr. McHugh, who is present in my office. Please state your name, sir. John McHugh.
All right.
Amy Reiser on behalf of the people.
So
hey, what are we doing today?
We would like an exam date. The people have graciously provided discovery, and we are prepared to go forward with the exam.
Would you have your witnesses available the 21st?
Because he's out of custody, could we have a later date?
28th work?
Yes.
All right. Any objection to the 28th, Mr. Margolis?
I don't believe so, Judge. No.
January 28th, 2025, 9 a.m. That is before Judge Washington.
Thank you.
Bond continue.
Thank you, Judge.
Thank you. Court calls the case, People versus Chloe Whitsett. Excuse me. No, it's the T's are together.
So there's a attorney on behalf of the people.
Your Honor, may I please have 10 minutes, please?
Yes, ma'am. Pardon? I guess. I just gave somebody 10 minutes. Court calls the case, People versus Gracia Cheatham.
Jacob Kennedy for the people.
And good afternoon, Your Honor. May it please this honorable court, Rita Young, appearing on behalf of Ms. Cheatham, who is present by Zoom. Ms. Cheatham, could you state your name for the judge, please?
Grace Cheatham.
Thank you. All right, what do we do?
Request an exam date, Your Honor.
All this is complete.
Yes,
My understanding that there was an issue with discovery.
There's an issue with
something,
discovery. What is it?
CSAM that needs to be showed to the defense counsel. Discovery is not complete.
well, Judge, I was told that I had to go to the prosecutor's office in order to view a piece of discovery and that I needed to sign a protective order, which I'm willing to do, but I don't want to hold up the exam. So if the court can set it out 2 weeks, I'll make the arrangements to go to the prosecutor's office and review it.
Well, I will adjourn the PCC for a couple weeks and then we can set an exam once I'm sure discovery is all complete.
Very well, Your Honor.
Probable cause conference in this case will be adjourned to January 23rd, 2025, 9 a.m. or as your invite indicates, bond will continue.
Judge, I have 3 other matters scheduled for that morning.
They'll
and
wait.
one matter in the afternoon. No, they won't because they're in Wayne County. So sorry.
Wow. You know, it used to be, Miss Young said I was her favorite.
You are still my favorite.
No, apparently that has changed. That's fine. I got tough skin. I'll make it. Will the 30th be a better date for you, counsel?
Yes, please, Your Honor.
All right, January 30th, 2025, 9 a.m. or as your invite indicates. Bond
Thank
continue.
you. Thank you so very much.
Thank you, Your Honor.
Court calls the case, People versus Charles Tingley.
I am Charles Tingley.
Just to hang on, Mr. Tingley, please.
Yes, sir.
Jacob Kennedy for the people.
Your Honor, Joe Simon on behalf of Mr. Tingley, and Mr. Tingley, now please state your name for the record.
I am Charles Tingley.
All right, I need a camera, please, also, sir. All right. What are we doing today?
Your Honor, on Tuesday, the court signed the order allowing the release of supplemental discovery that pursuant to that order, I can only review with my client, not send to him. So I'm going to make arrangements to do that. He's up in northern Michigan, not Hawaii, and he's not or anywhere else. But I'm going to make arrangements to do that with him digital or electronically, and I'm asking if the court will therefore adjourn the probable cause conference until that's completed, some 3 weeks-ish.
3 weeks? All right. Any objection from the people?
No objection, Your Honor.
January 30th, 2025, 9 a.m. or as your invite indicates, bond continued.
Thank you, Your Honor.
Thank you.
Your Honor, may I approach on an unrelated matter?
Yes, sir.
I know him, but he didn't know me.
What?
He's a supervisor?
Absolutely. Because now they have to go around introducing themselves. And he got up, started talking. I didn't know who he was. I said, fine. Nobody over there saying anything. I guess he's legal. I don't know. I don't know. And then he finally comes up on his own, introduces himself. We had a great conversation. And then all of a sudden you want to step in.
Showing initiative.
Okay, see?
Thank you. My people are self-sufficient.
So that's it. All right. Court does call the case of the People versus Adrian Vasquez.
Stephanie Cannon on behalf of Mr. Vasquez. Mr. Vasquez, could you please state your name for the record?
Adrian Vasquez.
All right. What are we doing?
Your Honor.
You're requesting an
turned in
adjournment?
a green sheet. I turned in a green sheet. Yes, we are asking for adjournment of this matter. I have sent an email regarding the additional discovery needed. Once we have that discovery, we will try to come to some sort of resolution on this matter.
All right.
For discovery.
Probable cause, January 30th, 2025, without objection, 9 a.m. Bond continued.
Do you need? January 30th. I'm gonna call you like always.
Okay.
So,
Thank you. Court calls the case, People versus Vershawn Vincent.
Ashley Lonnie for the people. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Vincent, who should be on Zoom.
Oh, I do see the name. Vincent?
Yes, I'm here trying to figure it out.
Okay. No, you're good. You got it. State your name.
Rashawn Vincent.
Thank you. All right.
Your Honor, we are asking for an adjournment to continue some plea negotiations, as well as Mr. Vincent wants to review some of the video discovery. I will get that sheet to you.
You'll get it right to me? All right. Probable cause conference, January 30th, 2025, 9 a.m. And I trust you, Miss Apple. You'll get it to you. I can really, not so much. Court calls the case, People versus Lawrence Watkins.
Ashley Lonnie for the people.
Stephanie Cannon on behalf of Mr. Watkins, who's appearing to my right. Mr. Watkins, could you please state your name for the record?
Lawrence Watkins. All right. What are we doing today?
Your Honor, my client is going to waive his preliminary exam. Did you get the form?
I don't have the form, but that's okay. Is that correct statement, sir?
Waive with we had an agreement to waive.
You can keep your hands out of your pockets, but there was an agreement on it. Go
That's
ahead.
correct, Your Honor. The offer to waive is to waive as charged the sentencing agreement to probation and no upfront jail. However, there is not an agreement to not habitualize this person, so the habituals will still be filed, but there is an agreement to probation.
Okay.
Your Honor, that is my understanding as well. As of today's date, however, habituals have not been filed.
All right. So under those terms, you're waiving your right to have a preliminary examination, sir?
Yeah.
You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand that you will not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Thank you, Your Honor. We would waive formal reading of the information and we stand mute as to the charges.
Defendant wait for with standing mute. Court will enter not guilty plea as to both counts. Pre-trial in this matter will be set for
February 27th at 1:30 before bench slide.
You said 27?
Yes.
February 27th, 2025, 1:30 before Judge Slag.
She's in the 22nd Circuit Court
All right.
downtown.
Thank you, Your
Okay.
Honor.
Bond in this matter will continue. All right, take care. He told me he paid you that money back, did he? Okay, all right. I thought he was telling me the truth. I just wanted to make sure. Okay. Take care. Court calls the case of the People versus DeAndre Wilburn.
Public defender, really on behalf of Mr. Wilbur. Approach Mr. State your name for the record, please.
DeAndre Wilburn. Thank you.
Judge, we're requesting an adjournment.
Okay. Without objection, probable cause will be adjourned January 30th, 2025, 9 a.m. or as your invite indicates. Bond continued. All right. Okay. Thank you, sir. Thank you. Court calls case People versus Luther Williams Jr.
I'm sorry, Assistant Public Defender, Tanaza Carey, I can really, Your Honor, on behalf of Mr. Luther Williams.
Luther Williams.
We're requesting an adjournment in this matter as well, Your Honor.
Probable cause conference, January 30th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. Court does call the case of the People versus Renee Williams.
Ashley Lonnie for the people.
Brian Bowley on behalf of Miss Williams, Your Honor. Unfortunately, I was unable to reach Miss Williams in advance of today's hearing, Your Honor. This was not a situation with a bad email, by the way, but I was unable to reach her, so I don't have any explanation for her whereabouts.
I bet you Ballinger did something. All right. Bench warrant will issue for defendant's failure to appear. Bond 10,000, cash surety. Immediate, that warrant will issue immediately. Thank you.
Thank you.
Court recalls case of the People versus Whitson.
So there's a pan on behalf of people.
Good afternoon, Your Honor. Kia Hickman on behalf of Miss Chloe Whitsett. Miss
Whitsett, if you got a camera.
Yes, am I here?
You're here.
Yes. Okay.
All right, there you are. Okay. State your name for the record.
Chloe Whitsett.
All right, very good. Okay. Where are we today on this?
Yes, Your Honor. So I just want to say for the record that I've been contacting more courts than 36th District Court for the mental health court. I did speak with one of the representatives from the one at 36, and he stated that the issue is staffing. They are bringing on 2 additional probation officers, and we should have an answer within the next 2 to 4 weeks because that's what's been holding them up. Also, I'm working on speaking with someone higher up as well.
All right. So you need more time to try to get this accomplished. Is that what you're telling me?
If the court would be so gracious, I know the people in the court have been, allowing us to get this figured out, but unfortunately, we're dealing with,
I hear you. Don't worry. I got you. Is there any objection from the people?
I don't have an objection.
All right. And Ms. Whitsett, how are you doing?
Well, Your Honor, thank you for asking, but this COVID has kind of whooped me.
Okay. All right. But are you at least moving upward from it?
Yes, sir. I was able to get my license paid and it is no longer suspended.
All right. See? Okay. All right. Well, counsel, if Miss Whitsett keeps smiling and acting like this, then I'll give you whatever time, because that first day, woo.
I know Ms. West. I know she's my saving grace, Your Honor. I know, but I'm working really hard to try to get this resolved.
I know you are, counsel. So let's do this. They say that it'd be about 2 weeks. That's not going to happen. So let me adjourn this out. February 6th, will that work? Give you about 30 days, another 30 days to try to get it done?
Yes, and I will be looking at, continuing to call other sobriety, mental health courts as well.
I know that you're working on it, and I think that would be the best solution for Ms. Whitsett. So we'll work with you as best we can on it, okay?
Thank you.
So,
I really appreciate the people and you all.
February 6th, 2025, 9 a.m. Ms. Whitsett, even through COVID and everything, you keep smiling. You hear me?
Yes, sir. Thank you so much.
All right. All right. You're welcome.
Your Honor,
Yes, ma'am.
do you think we could get on the email list? Because the prior attorney, she's getting the emails and she's no longer with the firm.
Okay. So
their office earlier today, so they're aware.
So is she getting on the, I think her email? Oh, so your office, say that again. I'm sorry.
I think Caitlin is the contact, Caitlin Crapo, but she's no longer with the firm.
She is listed as the attorney of record, Ms. Crapo, so we just need new paperwork for whoever the attorney of record is.
Oh, but see, I think she's listed as the attorney of record, but she was part of a firm. She's left the firm.
Mm-hmm. So we filed an appearance, but if we need to do it again, we will.
Well, technically it would be it won't really be a
sub.
Gone. Yeah. But if you could do that, but I'll tell you, in the interim, send your email to Ann in my office just to make sure that it's at least sent, even if so we'll make sure that you get that. Okay.
Okay. Thank you, Your Honor. I'll have our team send over a sub as well.
All right, very good. I like that.
Perfect.
Council, she got a whole team. I don't know how she did that. All right, anyway.
Todd has
All
a whole team.
right. All right. You guys take care.
Thank you, Your Honor. You as well.
Thank you.
All right. And that's it for that block? That's it for the whole day? Serious? We're done? Today done? That's it for today? I thought I had one more block. Okay, 14A stands adjourned. I'm good.